The case is now being live streamed. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Englander and Grant will be the panel for this case. I assume you've argued on Zoom before. It works pretty much the same as in person. Each side gets 15 minutes. You needn't take all of your time. We do not entertain rebuttal. We have read everything, so it's my best advice that when it's your opportunity to get right to the point. If we have any technical problems, we will suspend the argument and we will try to reestablish connection or fix whatever problem that we have, and no one will be discounted anytime. With that, I will call our case. It's 2020 P564, John Doe versus the Sex Offender Registry Board. Ms. Hernandez.
Good morning. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant, John Doe. The Sex Offender Registry Board classified my client as a level 2 sex offender. I'm here today requesting that this court remand the case back to the board for another classification hearing, as the hearing examiner's decision was arbitrary and capricious and an abuse of discretion. Specifically, the hearing examiner committed 2 errors in applying the regulatory factors in this case. First, the hearing examiner erroneously only gave minimal weight to risk mitigating factor 33, which is home situation and support system. The hearing examiner indicated that the letter writers, the people that submitted letters in this case, failed to indicate how specifically they plan to support my client. Additionally, the hearing examiner indicated that the letter writers didn't give any indication that they were aware of my client's sex offending behavior. However, if you read the regulatory factor 33, it does not require that letter writers indicate exactly how they plan to support an offender. Additionally, these letters.
Excuse me. But
yes.
If they don't, isn't he entitled to weigh it less since they don't offer any specifics?
Well, not required to. So if you read the decision and indicate, it almost sounds like the hearing examiner thinks that they're required to. If you look at the facts in this case, and if you read how factor 33 is supposed to be applied, it indicates that the likelihood of reoffense decreases if an offender is living in a positive and supportive home environment. In this case, my client was living in a positive and supportive home environment. As you know, he owns a house with his longtime partner. He lives in the house with his longtime partner, with his 2 children. And in addition to that, he lives there with his both of his in-laws.
You know, I didn't see some of that in the letters. I didn't see how many children he had. I didn't see that he lived in the house with them. Where is that in the record?
So that appears in the report that was submitted. He was evaluated in 2014, and a report was submitted. And if you want, I can look for the specific. Well, I could tell you.
No,
but it's not in the letters, though.
Yeah, so that factor doesn't even require letters to be written. It just indicates that the likelihood of reoffense decreases if a person is living in a supportive home environment. The hearing examiner doesn't have to gather that from a letter that was written. They gather that from the entire record. And in this case, according to the entire record, my client is supported by his family and does live in a positive home environment. Again, he owns a home. He owns it with his long-term partner.
The hearing examiner, in applying this factor, consider the fact that when this crime happened back in 2009, the defendant's daughter, or sorry, the plaintiff's daughter by this letter writer was just born or about to be born. And at the time when the letter writer wrote the letter, that daughter would have been about the same age as this victim was when the touching happened. Could the hearing examiner consider those things?
Well, the hearing examiner did not indicate in the decision itself that was one of the reasons why he gave less mitigating weight to this risk mitigating factor. But again, I would assert, just if you look at the totality of all the facts in this case, he did receive 2 letters of support, one from his longtime partner and one from his stepmom, all indicating that basically that they're there for him. and they describe him in a very positive way. They describe him as a respectful, hard worker, good provider, and a good and respectful son.
Yeah, they do say those things. And I think, and I take your point that that is indicative of family support. But one of the things that the regulation specifically talks about is whether they're aware of the offender's sex offense history and are there to provide guidance, supervision, and support of rehabilitation. There's no indication in the letters of that portion of what's considered in the reg, right?
Well, I would assert that the letters were actually written for the purpose of providing them to the Sex Offender Registry Board. So I think a pretty reasonable assumption could be made that they were
There's
aware.
nothing in the letters that indicates that the person who was writing that knew that.
You are correct, but according to the regulatory factor, that only applies. So if the writer or if the people who are providing him with support know about his sex offending behavior, that is when the hearing examiner could give greater mitigating weight. So I'm not arguing that the hearing examiner should have given this factor greater mitigating weight, only that he should have given this factor just threshold weight. He should not have decreased the risk mitigating weight of this factor. So that's basically what I'm arguing.
I understand the point, and I'll take a look at what the report of the psychiatrist had to say about this. But I think what's going on here in part, and correct me if I'm wrong, is he went to trial. He denied apparently that he had done this. There's no indication in the letters that they're aware of what they're sending that letter about. And so there's a backdrop that it's not clear to the board that he's accepting that this event occurred or that his spouse is even aware of it.
So that is true. There's no indication in the letters themselves that these two letter writers know regarding my client's sexual offending behavior. But again, the factor 33 only takes that into consideration if the hearing examiner is going to give this greater mitigating weight versus threshold. So my argument is that the hearing examiner should have just given it threshold weight, not that he should have given it greater risk mitigating weight. And for these reasons, I would assert that the hearing examiner erred by giving this factor less weight than what he should have given it. In addition to that, the hearing examiner appeared to not give any consideration to the 2014 report that was submitted. It was a psychological evaluation. And if you read factor 35.
Where is that in the record?
The psychological evaluation?
Yes.
It is in volume 1, it starts on page 153. So volume 1, page 153. And so there's no indication that the hearing examiner does mention the report in the decision. However, there's no indication which parts of the report the hearing examiner considered or didn't consider. There's basically no discussion within the decision regarding this evaluated report. And it's very important because these two people were the only ones that actually interviewed my client, that actually evaluated my client. And they performed 2 tests and found that my client was well functioning, suffers from no personality disorders, has no sexual interest in children, and poses a low risk of reoffending. Yet there's no mention of any of that in the decision. And as you know, the hearing examiners are required to provide detailed findings and give an indication that they place close attention to the evidence submitted in the case. And here I would submit that there's no indication that the hearing examiner really even considered, or they could have read it, but also they could have ruled out some portions or ruled in some portions, but there's no indication that
what do you do with the regulation? And I think it's 803 CMR 117.5C that says that at the hearing, a party shall be permitted to introduce an expert witness's written report, including his or her opinion, only if the author is called to testify. The failure to call the expert witness to testify will result in the exclusion of so much of the report as expresses the expert witness's opinion.
So in regards to an expert witness, if these people would have testified, then the hearing examiner, would have had to at least pay attention to their opinion regarding my client's risk to reoffend. And since they didn't testify, they have the discretion to just totally not even take into consideration their opinion regarding the risk to reoffend. However, my point is that there was so much in this report and there was no indication, under 35, the hearing examiner is supposed to at least consider it. There's no indication that the hearing examiner considered it. It seems like the hearing examiner just flat out dismissed it.
Are you arguing that the hearing examiner should have considered the ABLE screening assessment as results as contained in the report?
The hearing examiner should have just went over what they considered, what they took out and explained the reasons why, and what they took in and explaining the reasons why. And there's no indication here that the hearing examiner did that type of evaluation concerning this report that was submitted into evidence. And if you read Factor 35, they're required to do that. They're required to at least consider it.
It's the same issue, though, that we've seen before in the last, which is the regulation provides a clear indication of what is needed to be done, which is to have the person testify, and then they don't testify.
So that is for the hearing examiner to take their opinion regarding risk of reoffending into consideration. These type of reports, the hearing examiner, they are supposed to. I mean, the language is, I think it's that they mandate. Let me just find it real quickly. It says the board shall consider evaluative reports, which this is an evaluative report. It's a psychological.
Where is the indication in what he says that he didn't consider it? I mean, in fact, he indicates that he did read it, right?
So let's see what page is on. Page 66 of volume 1. It just tells us, whoever's reading the decision, that that this was submitted into evidence. But there's no indication.
He says, I give no weight to the ultimate risk opinion. That's what he's told he needs to do, and what what the lawyers representing the the petitioner are told they need to do. You're not going to get any weight if you don't testify. They didn't testify. Then he says, I have considered some information with the assessment useful in my analysis.
Yes, and there's no indication what he actually took into consideration. That's my point. So they do indicate that this was admitted into evidence, and they do indicate, which they have the right to do, by the way, to say they're not going to consider the evaluator's ultimate opinion regarding his risk to reoffense, but they are supposed to consider aspects of the report itself. And there's no discussion about what they consider, what they didn't consider, and why. The only discussion is regarding that they give no weight to the ultimate opinion since they didn't testify. And that is fair, and that that is the right thing to do. But there's so much other stuff in here, such as my client has no personality disorders, he's well functioning, he has no interest in children. So they could have considered those aspects.
The point of having a witness testify so that the parties go question by question at the hearing, and there can be an objection and the hearing examiner can rule on the objection, where if the respondent just puts, or the plaintiff just puts in the whole report, you're saying that the judge has to go through the report line by line, fact by fact, as if the witness had testified, and decide what's admissible and what's not?
So I'll say this: it would have been better for the two evaluators to have testified. They unfortunately did not. I'm not sure why that decision was made for them not to testify, because since they didn't testify, the hearing examiner is not required to take the ultimate opinion regarding the risk of reoffense into consideration. However, Factor 35 is separate and apart from an expert testifying, and that says if a report is submitted into evidence, which this is a report that's submitted into evidence, the hearing examiner shall consider aspects of the report. The hearing examiner could totally say, you know what, this is a bogus report. I'm not going to take, I'm not even going to consider any part. But instead, the hearing examiner indicates that he did consider, see the language, the appropriate parts. I forgot how his language is. The assessment useful by analysis, but there's no indication what exactly from the report the hearing examiner found useful to the analysis.
You only have about a minute and a half left, so could you talk a little bit about internet publication?
Yeah, I'll just say that the board failed to prove by clear and convincing evidence that the public safety interest is served by internet publication of my client's personal information. Again, he committed his index crime many years ago, 2009. He hasn't reoffended. This is his sole criminal conviction on his record. He's in his 40s now. This is the only thing that appears in his record. The offense was not a violent offense. It involved a brief touching of somebody he knew, and it occurred in a private location.
What about the fact that in 2012, your client lent a cell phone, his cell phone, to someone to take a picture individually of this little girl? Doesn't the fact that, can we infer that the fact that the cell phone would have access to the internet give us more reason to uphold the requirement that he have internet posting?
Well, honestly, there's not that much information in the record regarding that. I know that when she was interviewed in 2012, that is the assertion that was made. I mean, bad judgment, obviously, but not a sex offense. Nothing indicating sexual in nature at all. And again, if you were to register as a level 2 and register with the police department, I would assert that that provides the public with enough safeguards in terms of protecting the public from my client.
Okay, thank you very much.
Thank you so much.
Mr. Bosse.
Thank you. May it please the court, good to see the justices of this panel. The SWORD respectfully requests that the level 2 classification be affirmed by this court. We believe that the classification level was reasonable because there is the high risk factor of a sex offense against a child. The plaintiff, the appellant, was 30 years old when he sexually assaulted a prepubescent 9-year-old female victim. So based upon that factor, we believe the classification level is reasonable. We also respectfully submit that the hearing examiner properly considered all of the mitigating evidence in this case, particularly factor 33. As was discussed, there was the support letters from the appellant's girlfriend and stepmother. However, the examiner properly did not give full mitigating consideration to factor 33 because—
Well, he says he gave minimal.
Right. And
That's a little different than not full. It's
that's
like
correct.
He discounted it entirely. The guy is living with a wife or with a long-term girlfriend, 2 children, has a job, that he's gainfully employed. He has a single sex offense, which is how many years old at the time that I'm struggling? Isn't it 9 years old at the time that the hearing takes place that we're talking about?
Well, so by the time that the hearing examiner issued the amended decision, it was 10 years old, right? Because the sex offense occurred in 2009 and the amended decision was issued in August of 2019.
And he gives minimal weight to risk mitigating factors associated with his stability in the community.
Hmm.
I mean,
Yeah.
that doesn't, I got to tell you just flat out, that doesn't comport with the usual cases that I see that come from the board. I mean, this is a set of facts that usually gets more than minimal weight. And
I
that
agree.
seems kind of arbitrary.
Yeah. Justice Englander, you make a good point. I think if I was a hearing examiner, I would have given a little more weight and then explained, because the letter writers did not explain that the knowledge that the appellant was convicted of a sex offense and what support and guidance they can give him because he was convicted of a sex offense. Yeah, I think was proper to not give the full mitigating weight, but you bring up an excellent point. I still don't.
As far as risk factor 29, offense-free time in the community,
Sure.
when does that start to run from? Does it run from the date of the offense or from the date of the conviction?
It runs from the date of conviction. In this case, it truly ran from his date of conviction because he was placed on probation. If he had been sentenced to state prison, the House of Correction, it would have ran from his release date.
Release date, yeah. So when was the conviction date? I was just looking for that.
The conviction date was in 2012, and he's had almost, by the time that the hearing examiner issued the amended decision, he had almost 6 years of offense-free time. So to me, that puts him not in the level 3 category, not as a level 1, but I think it was reasonable to put him at the level 2 because
Who put him in a level 3? I mean, he was fighting level 3 for years, right?
correct.
How could anyone justify putting him in a level 3 under these circumstances? I look at this and I've now had enough experience with the board to see an array of facts, and I say there are things here that don't make sense to me. That he was a level 3 initially makes no sense. That he gets minimal weight for his community makes no sense.
Mm-hmm. And Justice Englander, I generally agree with a lot of your opinions. So I'm not the hearing examiner in this case, but I think that it.
I appreciate that, counsel.
No, I really do think that this case, I mean, perhaps an argument could be made back in 2014 that he was a level 3 because the sex offense was fairly new and he didn't have the offense-free time in the community. But if I was a hearing examiner, even back then, I probably would have made him a level 2. But I still think a level 2 is justified years later because the science show that this is
it was a 30-year-old on a 9-year-old. Basically, it comes down to that. Right?
It does come down to that, as well as the science that says after 10 years of offense-free time in the community, your risk to reoffend substantially is lower. So with that said, the good news for a person like the appellant is that they do have the right to reclassification. So if he can continue to show some stability in the community, which is a good thing, you know, he has a house, he has employment. If he can continue to show that stability, he does have a remedy of filing a motion for a downward reclassification, which would be 1 year from this August.
What about your sister's argument that there's nothing in the examiner's report that reflects a real consideration of the expert's report?
Yes, so sure. I think Attorney Hernandez brings up a good point. On one hand, I disagree. Well, I think she agrees with me that because the expert, in this case, the therapist didn't testify under the regulatory factor, the hearing examiner could not consider the therapist's risk opinion. However, the examiner was required to consider any useful and relevant information within that report. The examiner said that he did. He didn't go into much of an analysis about it. But
what do we do with that? Okay, so you have, I mean, this is a case with many mitigating factors, right? There are at least 4 of them, but one of them is he was examined by experts who concluded that he had minimal risk of reoffense. And we don't have any indication that the examiner grappled with that. He sort of said, well, I don't have to consider the ultimate, and that's right. And it's understandable why the regulation says that. But there's nothing further. I mean, what are we supposed to do with that as a reviewing court?
Yeah, sure. So I don't think it's prejudicial in this case, although the hearing examiner, I think, should have given more of a detailed analysis under Factor 35. But I don't think it's prejudicial because I think that the therapist's report was pretty thin to begin with. And much of what the therapist talked about was addressed under other mitigating factors such as,
What about the fact that the expert's report found under the AASI at volume 1, page 158, found some problems with the offender, saying that he his scores on the cognitive distortion scale shows that he may minimally use justifications and minimizations. And more importantly, on the social desirability scale, his scores were 95 out of 100, and 65 to 100 is considered highly problematic, showing that he may try to minimize major faults and problems. Now, I understand that under matter of Reedy, there's issues about the admissibility of the AASI, but if are you arguing, or are you conceding that the hearing examiner should have gone down this path and decided to admit or not admit all of these parts of the report, some of which may be favorable to the offender, some of which may be unfavorable?
So under Reedy, my argument is that the hearing examiner shouldn't have considered any of the information under the ABLE assessment, because the Reedy court went into detail explaining why the ABLE assessment is not scientifically reliable. However, in an
That
interest
was
of,
in 2000 and
right. So in an
what was
interest
the
of,
year? 2000. When did Reedy come down?
Reedy was, it was early, I think it was 2005. I have it,
Right.
2005.
15 years
but
ago. I don't know, and I've read it before, but I remember coming to the conclusion that Reedy wasn't necessarily forever an indication that this particular assessment was invalid. And presumably if the experts are using it in 2014, there's some at least implicit statement on their part that they consider it to be a valid analytical tool.
So Justice Englander and Justice Grant, I'm glad that you brought up the ABLE assessment, because at a prior oral argument in February, I wrote my brief in January, but Justice Englander, you were on that panel, and I made the similar argument about the reliability of the ABLE assessment. And I thought you brought up a good point that Reedy said that they analyzed the ABLE assessment. They didn't say what version. And it's
Right.
presumed that over the years, they've updated the ABLE assessment. So I can't say for certainty whether this court would continue to say that the ABLE assessment version that's been used in recent years would be scientifically reliable.
It's a difficult position for us to be in. If there's nothing from the expert that says, hey, I'm aware that in the past this has been criticized, but now it's become something that is used regularly and it's actually been updated. If there's nothing like that, we're not in a position really to address that question on appeal. There need to be some facts around it, it seems to me.
Right, and I'll just say that the same. I agree with you. You made a good point back in February. Make a good point today. My only statement to that is, when you do look at how the Reedy court explained what the ABLE assessment test is, and when you look at how the therapist in this case explained what the ABLE assessment test is, I don't see much of a difference, but perhaps over the years, with the different versions, that there have been some slight adjustments.
Doesn't even necessarily have to be a different version. It may have been, early in its usage in 2006, and it may be that data now validates it scientifically. But if we don't have the evidence on that, I understand the point, counsel.
Mm-hmm.
Nobody put in anything like that in this case that I saw.
And just getting back to Justice Grant's point, to me, when I look at this therapist report, there was a lot of emphasis on the ABLE assessment. And the only thing I'll have to say about, risk assessment tests like the ABLE assessment, I think like the ABLE assessment, the phallometric assessment, and the static 99R, these are a lot of risk assessment tools that are used by therapists in treatment. But I also think that over the years, this court, as well as SJC, has properly criticized some of the problems with these tests. And I believe that the SORBS classification scheme is a lot more reliable than these risk assessment tests.
Well, the SORB's classification scheme requires that you consider what the experts say. And if the experts are using these tests and they're saying that these are scientifically validated tests, I can't see how you can not consider what is presented by the experts pursuant to a test of that particular person in front of you. You can't discard it.
No, you can't discard it. I'm just saying that part of my job is, I have been looking at the SJC and this court's opinions about some of these tests, and I think that that the SJC and this court have done a good job of showing some of the problems with these tests. And
you've less than a minute left. Could you talk about internet dissemination?
Sure. It's just the SORB's view that because there is substantial evidence to support the level 2 classification, a public safety interest is warranted by having the appellant's sex offender registry information disseminated on the internet for the protection of minor female victims. And if I could just bring up one additional point, I know I'm just bringing it to this court's attention because I know that this panel sees a number of SORB cases. There was a declaratory judgment declaring the first part of Factor 2, repetitive and compulsive behavior, unlawful and unconstitutional. So
thank you.
I just wanted to bring that to the court's attention.
We are aware of it. Thank you.
Okay.
Thank you both. We'll take it under advisement.
Thank you.
Thank you.
The case is now being recorded.
Thank you. Welcome to the appeals court. I'm Justice Meade. With me this morning on the panel are Justices Englander and Grant. Each side is provided 15 minutes. You needn't use all of your time. We've read everything. We do not entertain rebuttal. If we run into any technical glitches, we'll suspend the argument and try to reestablish any connection, and no one will lose any time. With that, I'll call the case. It's 20P1040 Kimberly Parker versus Kevin Parker. If you're not arguing, can you please mute your microphone? Ms. Sweeney.
Thank you, Your Honors. As you know, I represent Kevin Parker, commonly known as Kit Parker, in connection with these proceedings. I did not write these briefs. I'm merely arguing the briefs, and there seems to be two salient issues with respect to the lower court, Judge Monks' original judgment, one of which is the use of the term alimony. I think we need to take the use of that term in context. My client has been using that term throughout his relationship and in the essence of providing support payments to his former spouse.
Excuse me, did you mean allowance? You said alimony.
Yes, I said allowance. He has been using the term allowance in connection with his support payments, which are both a combination of child support and alimony payments to his former spouse, since the issuance of the original judgment of divorce nisi. As Judge Monks correctly pointed out, many states use the term maintenance and allowance in lieu of alimony in connection with their own statutes. Judge Monks was very clear that if there is an issue raised by the mother saying, I prefer you not use that word, and father continued to use that word, then it could be construed as disparaging.
I have a question. If
yes.
he had called her an obscene word, could that be considered disrespectful, or would she have
Absolutely,
to say?
yes. No, I think that, I mean, I have been doing what I do for almost 24 years now, and I can tell you that disparaging, usually when you see it, it's very abundantly clear. It is, really inappropriate. It is foul language. It is something that any reasonable person would look at and say, wow, that's definitely disparaging.
But the word here is respectful, though. Businesslike and respectful. It's not disparaging.
Well, businesslike and respectful. I think if you saw something that wasn't businesslike and respectful, I think you would easily be able to discern that through the multiple email communications that these
Well,
parties have
maybe
had.
not, maybe not, maybe, so I take your argument with respect to the word allowance, but not your argument with respect to you're gonna know it when you see it, when it comes to respectful necessarily. I mean, this was not, there was no evidence taken here, right? This, except for the emails themselves, I guess. But if we were in a different context, not talking about the word allowance, but talking about tone and content, which is exactly what the provision of the divorce judgment talks about, there could be, couldn't the judge find a lack of respect in the tone and content of email that is not overt in a particular phrase, but that comes from something that develops over a period of time where the court can make the finding that this is disrespectful in the way that's being provided?
So then let's look at the particular references that counsel for mother raised in her briefs. So she basically goes on to point in the salient record to page 84, which she says and represents to you in her responsive brief is the mother directly telling the father, do not use the term allowance, which was something that Judge Monks found that if in fact the mother had made that statement and then the father continued to use that statement, then it could be construed as disparaging. But if you look at page 84,
Subsequent to that, on page RA 78 in July of 2019, so that's 3 months later, he did use that word again.
yeah, so I want to point out that the other side used pages 77, 78, and 84 as reflective of their position that he continued to use a disparaging comment. I think we can all dismiss page 77 of the brief because that's a 2018 email. The first time mother ever said anything about the term allowance, she didn't say don't use the term allowance. If you look at the bottom of page 84, she says, you are also in contempt as you have not provided the supporting documents to me in a timely manner regarding February payments of child support, which you have been incorrectly calling an allowance in past emails. She never says in that
at page 77, he said your allowance. And if, as you're saying, that encompasses the child support, for him to be saying that his payment of child support is your allowance, then that the judge could find that's disrespectful to her and to the children.
But then you also have to take your plaintiff where you find them. My client's been in the military for 28 years. Military pay and allowances is a common, normal term that he uses in her vernacular. And it means that any funds a soldier receives in addition to their regular pay is considered an allowance. So for him to, for example, Google the word allowance in connection with support payments in Massachusetts, he's going to find replete cases that deal with the word allowance. So how would he be on notice that that would be a term that would be contemptible? It doesn't really rise to that level of disrespectful tone or comment. My client has been very careful to communicate with his co-parent in a manner which he thought would be respectful and kind. And at no point in time was he put on notice, do not use this term ever again. I find it offensive. And so if she simply says that's the wrong term or you're incorrectly calling it, I don't think that would have put him on notice in the meaningful way that Judge Monks required when she said, if it's raised saying, I prefer you not use that word and other parent continues to use that word, then it could be an issue of contempt.
It just pointed out, well, maybe it did, maybe it didn't, I don't know.
So then take a look.
She pointed out that he's incorrectly calling it allowance. He uses the term a few months later. She asks him a question and he says, oh, that's a very interesting question. We'll take it up in front of the judge. That happened on a couple of different occasions, right? So, what the emails indicate is two people who aren't talking very well. In fact, judging by the opening of the argument in this case, it sort of suggested to me maybe lawyers who aren't talking very well, because the lawyers were there on 5 contempt issues, 4 of which were declined. And the first representation of the judge was that they hadn't even talked about it, which I found kind of astonishing, frankly.
So in my world, and I'm new counsel to this case, if parents have an inability to communicate, and you can read this from the lower court's record, you ask that the court appoint a parenting coordinator, which is something my client asked for and something that mother rejected, or you find a
Because she would
electronic
have to pay
method to
for it,
use.
right?
Not necessarily. I mean, one parent can, if you want a parenting coordinator that badly, and I certainly do it in my cases, I would
think-
have
I
my
actually
client
think
pay
we're-
for that.
I think we're getting off point now, because these are the
But the
things.
second,
that
the
a
only
lot of
other option that you have in a probate court when parents can't get along and can't communicate is they have electronic mediums such as Cozy software system or My Family Wizard, which actually tracks and monitors the communication between parents and helps them make sure that the communications
Or
are
the
respectful.
lawyers can help the communication, but can we move to the next, to the next issue, which is
Sure.
the issue of whether the order cut into the husband's parenting time. And it seems to me on that one, the problem that I'm having is that there seems to be an inconsistency in the original judgment between the assertion of parenting time and the assertion of who has the ability to make final decisions as to the child's education. And so tell me how we should think about that, would you? Because didn't the judge have to resolve an ambiguity that was in the original judgment?
When I look at a parent who has what I would call a very standard, more old-fashioned parenting plan, which this father has, it's Friday to Monday morning delivery to camp or school with a Wednesday dinner visit. I look at that very differently than a parent that has a 6-8 schedule or a 50-50 parenting plan schedule. And you really want to preserve the parenting time for that parent so that he can enjoy spending time with that child during the limited blocks of time that he has. I also look at whether or not there's an activity that can be done, not at a time when the other parent is having parenting time. In this case, we have a mother who is the CCD teacher. She is the director of the CCD program. She can decide when she wants to hold the CCD classes in the underlying
That's
record.
a brand new argument. Nobody suggested she could have done it at a different time, at any time in any of the briefs that I've seen up till now.
That was
I mean,
part of the transcript that was
No,
of the
transcript said-
underlying hearing.
Transcript complained that he, I'm sorry, counsel, that this is a new argument, right?
I believe that each of the parties raised this in the transcript, and mother had a response to that and said, for example, that there were oftentimes many children in my class, and she named names of other children in the class, but then she also acknowledges, and Attorney Sweet will confirm, because she was there and I was not, I only read the underlying record, that there were times when only mother was teaching this one particular child, which begs the question, why can't she teach this child on times when it doesn't impact the father's parenting time? And then when I look at Judge Monks's discussion on this, and I look at Attorney Sweet's argument, Attorney Sweet specifically said, we are not trying to prohibit the father from going away during his parenting time. His family lives in Alabama. That's also in the underlying record. And we're trying to balance that by filing a complaint for contempt, which did exactly that. It complained that father not only wasn't taking this child to CCD classes that mother teaches on his parenting time, but they also complained that he wasn't attending the very same church that mother was attending, even though both father's church and mother's church are the same religion. There is no variance.
So is this argument an argument that the judge abused her discretion when she entered the order that said that he has to bring the child to CCD unless he has 4 consecutive evenings?
I think it was. I think it infringes upon his parenting time. And as everybody acknowledged,
If I might, let me, if I can get in the questions, it's going to be a little bit easier. So then you need to try to help me understand why that's an abuse of discretion when the definition of major decisions in the original judgment said major decisions affecting the child's health, education, and general welfare shall include, but not be limited to, change in any religious instruction. And whereas I understand the facts, up until 2017, the child was going to CCD at this school. at this church. So why is it that the judge abused her discretion when the original judgment said that this is a major decision committed to her?
Subsequent to the issuance of the judgment, the mother made the unilateral decision to send the child to Lexington Christian Academy. As part of the Lexington Christian Academy academic program, there is religious education and training on a daily basis. It is highly unusual for a child to get religious education and training on a daily basis, and then also attend CCD on a Sunday. Usually, when you go to a private Christian school and receive that training, you no longer need to go to this Sunday program, but the mother
Was this
insisted.
argument made to the judge? I do not recall seeing this being made to Judge Monks.
There was arguments made to Judge Monks on the issue of Lexington Christian Academy, but there was not a presentation made to Judge Monks that is part of the routine curriculum and program.
Because she's exercising her discretion to try to resolve an ambiguity. And I grant you your point, which is that this interferes with his parenting time significantly on a Sunday. But if the argument you're making now wasn't made to the judge, it's kind of hard for her to exercise her discretion and take that into account.
I don't disagree with you, Your Honor. But I am asking that you overturn that decision and allow my client to have unfettered parenting time, or at least that you provide him with some number of weekends a year when he can actually exercise his full parenting weekend and take the child away, in view of the fact of the arguments that were made during the lower court that mother, when she wishes to travel with the children, she simply cancels CCD. She does that. She did that just this past weekend. So it seems as though she's using her teaching of CCD as a sword so that she can preclude the father from exercising meaningful parenting time on a regular basis, but also as a shield.
Can I ask something to clarify? For there was no attorney's fees awarded here.
True.
So the sanction is the change in parenting time?
Yes.
Okay, then nothing else.
No.
Okay.
But for my client, that was a very, very big sanction.
Well, I'm not implying that that's insignificant.
Well, it's actually not even a sanction, is it? I mean, I think it's just her clarifying how the child will go to Sunday school, or how she will get her religious education, if you will.
I think we look at this a little bit differently. I mean, I've taught CCD for 11 years. I think it's very different when you are your child's CCD teacher versus if your child is going to a routine and ordinary CCD class. This isn't like a soccer program, which is going to transcend naturally each parent's parenting time, or a team sport. This is very different than that. This is a self-directed class by the mother that at times only has mother and child.
Thank you, Miss. Your time is up.
Thank you.
Attorney Sweet.
You're muted.
You're muted.
Muted again.
Attorney Sweeney, can you mute your mic, please?
Can you hear
Okay,
me
that
now?
looks good. There you go.
Okay, I'm so sorry about that. Thank you, Your Honor. I'll start with just briefly addressing Mr. Parker's first argument that he makes in his brief, which is that there was not a clear and unequivocal order which he could be found guilty of. And I'll just simply state that in a trial court's decision and a judgment, I think it would be impossible to list each and every example where in the future there may be disrespectful or unbusinesslike communication. If we did that,
But
I
it
think our
has
judge
to
would
be
be
clear
100.
enough so that he knows what he's been told not to do.
I'm so sorry, Your Honor.
It has to be clear enough so that he knows what he has been told not to do.
And Your Honor, if that was I've never seen a judgment that lists each and every potential
No, but it doesn't,
situation.
those two things are not mutually exclusive. The law is, it must be a clear and unequivocal order in order to find him in contempt. You simply can't do it if it's not clear and unequivocal.
Well, I think trial courts actually do that every day in terms
Well,
of.
then that's an issue.
Yeah.
Let
Well,
me ask
because
it
everything
differently. How is the word disrespectful not ambiguous?
I don't think it is. I think it's one of those situations where that is why the trial judge is given their discretion, because by its very
Well,
definition.
what might be disrespectful to one person, it would be ordinary to someone else. I mean, when Justice Grant sits down with Justice Engler and I for lunch, and we don't stand up when she arrives, that's disrespectful in some circles, is it not? In ordinary society, in a cafeteria, Justice Grant would just sit down at the cafeteria table with us, and no one would blink an eye. That's quite a difference, isn't it?
Yeah. And I think your point is well made, and I agree with you, because
So you agree it's ambiguous?
Judge Monks is very familiar with these folks. I mean, she did the divorce trial in 2015. They've been in front of her for years since. And so, of course, she's currently presiding over the pending modification action, which is still ongoing. She's in a very unique position to understand how these parties might interpret things. In fact, the transcript indicates that Judge Monks said as much at the hearing, that she understood how Ms. Parker could interpret this.
Then. Did the contempt complaint itself even mention the word allowance?
It did not. It did not.
And did not Judge Monks say at the hearing, well, if she had told him not to use that word and he continued to use it, then that would be a problem, right?
Right. And although my client
and wait a minute, there was a follow-up, sorry. And that didn't occur.
She did not use the words, do not use this term, but she did say that you're using that term incorrectly in reference to when he said your allowance, which is something that a parent gives to a child. And she told him that on April 11th, 2019. And of course, as you know, he then again used the term in July of 2019.
Well, the other thing that's interesting, and Mr. Parker makes this clear in his brief, that the word allowance appears both in 208-37 and in the child support guidelines when it's referring to child support. It's an allowance.
Mm-hmm. Although he does refer to that, and of course the word is in the statute, in the guidelines, we're talking about the context of communication between prior spouses where there is a history of domestic violence, where he was ordered to take a batterer's program, in which he did. And in fact, that resulted in another complaint for contempt for his failure to
and
provide.
that evidence is relevant to whether or not his use of a word that is in the statute and in the child support guidelines is disrespectful.
Absolutely, because the history of the parties is very relevant and in the way that they communicate with each other. And I will also note that her judgment not only just referred to the examples of allowance, her judgment said, taken in context of the other content and tone in his email communication. We provided the judge with a whole binder clip of emails, Your Honor, not just the select ones with the word allowance. And so I think—
But the only finding that she makes is with respect to the word allowance. That other language, it's there, but it doesn't tell me as a reviewing judge a darn thing. It doesn't tell me what else he did wrong.
You're correct.
The only finding is with respect to the word allowance.
Well, there's a finding with allowance, and then she also makes this reference to the tone and the context of other communications. We don't know more from the findings. I would agree with you more than that, but it's not just the word allowance. It is the tone and content of all of these other emails, which the Judge Monks had the ability to review and on which she made the decision. So I will also point out for the court that, of course, we know that there's broad discretion given to the trial court, but there's also, we're bound by any reasonable inferences taken by the trial court. And I think this is a perfect example of a reasonable inference where Judge Monks took the facts, applied it to the case, very familiar with this case and the background between the parties, and made the finding that she did. If there are no further questions on those, Your Honor, I would move to the issue of the parenting time and attendance at church. Okay, so father in his brief is alleging that the Judge Monk's order actually equates to a loss of his custody. And, my client's position, Your Honor, is simply because she is present, it doesn't equate to loss of his parenting time. She is teaching other
Take the fact that she's present out of the equation.
Mm-hmm.
He loses, he has from Friday night until Sunday night, basically 2 days, right? 48 hours. And this takes away 3 of the waking hours. Isn't that a loss of parenting time? I mean, he is being directed to put the child in a situation where he's not going to be present. In fact, I'm not sure he can even be present, right?
Well, he can actually, he did continue to attend. I'll point out for Your Honor that this is the Burlington Church of Christ where the parties attended when they were married, and with Mr. Parker continued to attend even after the parties were divorced.
Can he be where his daughter is while she's taking CCD from his ex-wife?
So I'll just, two things, Your Honor. First of all, he can be present at there's two components, which was explained in the judgment. There's actually Sunday school, which no, Mr. Parker could not be present, but there's also church worship, which he can be present for, and there's a fellowship in between those two activities. So yes, Mr. Parker can be present. And in fact, Mr. Parker was present for years after the parties were divorced. It was only until recently that he started not taking Caroline to attendance, and that's what generated, of course, my client.
No. The evidence, I'm sorry, counsel, the evidence that I saw in the record indicates that almost immediately upon the divorce entering, Caroline stopped going to Sundays at Burlington. That was the record that was put in by you. She went 9 times out of 26 in 2017. So
Right.
almost immediately, he is taking her someplace else, or she's not going to Sunday school. That's the evidence, right?
Right. Well, Your Honor, when I say 2015, that was when the divorce was tried in July of 2015. So between 2015 and then 2017, that's when he stopped taking her. So that's the time period, Your Honor, to which I'm referring to. The judgment on divorce came out in January of 2016. So there was a substantial period of time where Mr. Parker, in fact, did continue to bring Caroline, and he could be present and was present.
Was there any evidence in the record as to, so the divorce judgment enters in 2007 and 2016, you say?
January of 2016, yes, Your Honor. We finished trying the case in
Okay, I
July
got
of
it. And
2015.
so was there any evidence as to how often Caroline went to Sunday school in 2016?
I don't believe that there was. I don't believe there's anything specific with respect to 2016, Your Honor.
Okay, so what
but
I
I'll
saw
also-
was 2016, 17, and 18,
Well,
as
it
to
really,
which he went less than half the time.
right. His absences from bringing Caroline on his weekends certainly expanded as time went on. I do want to point out for the court too, there's a lot of reference to CCD, which is a Catholic. These people are Christian. And so my client cannot choose, just to address what my sister counsel brought up, my client can't choose when to hold these classes. These are happening on Sundays as a precursor to worship. So there is no option for my client to hold it a different day. So I just wanted to point that out. And I mean, I would say that Mr. Parker has the ability to be present in worship, obviously not at Sunday school, but my client is not having one-on-one time with their daughter. Occasionally, maybe sometimes she was the only one in attendance, but there certainly are other children attending this church. It's actually one of the reasons that Caroline looks forward to going there. She has formed friendships there. I mean, she has literally been going there since birth. She was brought there, started in the toddler program, and attended Sunday school as soon as she was old enough to. So we do look at this as an
The
activity
record
of the
seemed to me
child.
to be pretty inconsistent with respect to whether the child was alone. It seemed to me that there were there was an indication that at times there's as many as 5 children, but that it's sort of 2 to 5, and at times she was alone. Isn't that, I mean, doesn't the record indicate that?
Yes, absolutely it does. For that period of time when we presented in the fall of 2015, in prior years, Your Honor, sometimes there's more and sometimes there, the same amount of children obviously don't come every single Sunday. But for that period of time when we presented it to Judge Monks, that was the numbers that were presented. And of course, we're talking about a major life instruction religious activity, which is very important to these folks. And it was presented by my client that what father was doing was actually really a change in the child's religious instruction by stopping taking her there. It was a loss of time. And I do want to point out that in the judgment, Judge Monks
There's
provided
no
that-
evidence at all as to what was done in 2016. And so it's hard for me to evaluate whether it was in fact a change or not. And I think, I think the judge is actually struggling with it during argument. You can see she's trying to get facts out as to how things were done. And you just conceded, I think correctly, that there was nothing with respect to 2016, 2017 and 18. Mm-hmm. She's going less than half the time. So I'm not sure about what the record tells us as to whether that's a change. Mm-hmm. And isn't it a significant imposition on his parenting time? If he has to bring her there on Sunday mornings, and it's every Sunday morning on fear of contempt, he cannot take the child away for a 3-day weekend.
Well, Your Honor, that they provided that if she was going to be away consecutive overnights, that in fact, Mr. Parker could take the child.
Yeah, that's not an answer to my question. He can't take her away for a 3-day weekend because what you just referred to requires 4 overnights.
That is correct. The way the contempt judgment is written, Your Honor.
So
It's
isn't it a
for-
significant imposition on his parenting time?
Well, I think that has to be weighed against the religious instruction. And I would also point out that these parents, they've often, and I know this is not part of the market, but they've often been flexible with each other when there's been travel plans. They've accommodated, my client has accommodated Mr. Parker's travel plans for work numerous times, and nothing prevents these parties from reaching out to each other and making an agreement to do, oh, this is Memorial Day, I'd like to take Caroline away someplace. And in fact, they have been able to do that. But your point is well taken, but I think Judge Monks was trying to craft something that addresses both Caroline's best interest of continuing to attend her religious instruction, as well with Mr. Parker's ability to go away for holidays and vacations, which certainly he can do by the terms of this judgment. And she provided for that in 6B of her order. So, Your Honor, I just don't think that the church attendance is not unreasonably burdensome, given the fact that he is able to take the child away for 4 more nights or more. And Your Honor, I believe the other issue that we have not addressed in my remaining time is the legal fees. And that is that there is a presumption that if someone is found to be guilty of contempt, there's a presumption that there should be legal fees awarded, subject, of course, to the trial court's discretion. And of course, it's my argument that Judge Monks-
I took a look at the statute, counsel, and so you're going to get an indication of at least what I'm thinking from this question. In many attorney fee shifting statutes, they talk about a prevailing party. And if I looked at this, you're not the prevailing party. You lost 4 out of 5. Now, that's not the language of this particular statute. And so my question to you is there anything that suggests that you should get fees when you lose 4 out of 5? In other words, is there anything that evaluates who actually won?
Well, I don't look at it in terms of winning or losing it. Your question looks at things in the aggregate. There were 5 counts, only 1 he was found in contempt. Of course, there were 4 other counts that the judge had to provide.
Did you seek fees for all of your work in connection with this contempt motion?
That was contained in my affidavit, but certainly nothing prevents the
Okay,
judge
so
from
even
ordering-
though you didn't obtain relief of contempt on 4 of the 5 issues you raised, you sought fees for all the time you put into it.
Well, of course, because going into the hearing, I didn't know what the result was going to be. So of course, my affidavit included all of my time. It was
Are
only
you
afterwards.
still seeking fees for everything that you did, even though you didn't prevail on 4 out of the 5?
I think it would be reasonable, Your Honor, for my client to be awarded a portion of her legal fees, because his behavior shouldn't be excused simply because he wasn't found in contempt on 4 counts. He was found in contempt on 1 account. And I think my
his
client,
attorneys, and you caused him to incur the costs to defend against 4 allegations that were found not to be supported.
although not to be supported, it gave cause for Judge Monks to issue further instructions. For example, he didn't provide any documents.
That point's well taken. Thank you.
Right.
I appreciate
All
that.
right, thank you. Then, Your Honor, I have no further comments unless there are further questions.
Seeing none, thank you. Well, thank you both. We'll take this under advisement.
The case is now being recorded.
Thank you. Welcome to the Appeals Court. I am Justice Meade. With me today on your panel are Justices Englander and Grant. Each side is permitted to argue for 15 minutes. You needn't use all of your time. We have read everything. We do not entertain rebuttal. If we run into some technical glitch, the argument will be suspended. We will attempt to fix that, and no one will lose any time because of any technical problems. With that, I call the next case is 20P997, Trustees of Beechwood Village Condominium Trust versus USALLIANCE Federal Credit Union. Mr. Moriarty.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. Thomas Moriarty for the trustees of the Beechwood Village Condominium Trust. It's the trust position on appeal, Your Honors, that the land court decision should be reversed. The declarant's phasing right should be extinguished for want of purpose. The defendant's mortgage, to the extent it encumbers the phasing right, should therefore be determined a nullity, and the association should be free to exercise its rights under General Law, Chapter 183A, 5B23, to revive and grant a phasing right. The phasing right should be extinguished in this instance under the principle of want of purpose. The declarant's phasing right, it is undisputed, cannot presently be exercised. The exercise of the phasing right requires an opportunity and an ability to construct on the common area. General Law, Chapter 183A, Section 8F requires plans showing the layout, location, and dimensions of a unit to be recorded with a master deed, and cases interpreting that statute have applied that to phasing amendments recorded after the master deed is recorded.
Mr. Moriarty, can't the declarant seek permission from the unit owners to continue?
Absolutely, we could, Your Honor, but that brings the central question presented on appeal to an immediate head. The question, therefore, would be whether or not the ability to construct in the future, so not a question of whether they presently can, they cannot, but in the future, is it within the control of the easement holder, or is it beyond the control of the easement holder?
So that's what you draw from the cases. This is your central point. You say, if the ability is not within the control of the declarant, then end of his, what you call an easement. And the case you rely on primarily for that proposition is what?
So there are several cases that support it. The principal case that expresses the concept, Your Honor, I suppose would be First National Bank v. Connor, but all of the cases that we cite break down along those lines. So, I mean, it's, Central Wharf, Comu, Hamada.
But none of them say what you want us to say.
Oh, Your Honor.
None of them reach a conclusion that because the particular easement holder does not have control over the future, his easement should be extinguished now.
That is absolutely correct with regard to the specific holding. There is no case that specifically holds that principle. It's the plaintiff's position that it is clear from the facts and the holdings in that series of cases that the holding is justified in this case. In every circumstance, Your Honor, in every circumstance where the easement was not extinguished because of some future possibility of exercise, that is because in the future some condition could change that would allow exercise, it was fully within the control of the easement holder. And in fact, I
understand the point. We just don't. Can we back up for a minute, because I spent a lot of time last night, and it's time that I'll not get back, but maybe it was well spent. What is a phasing right? Articulate for me what the right is, and then explain to me why it's a property right.
So, Your Honor, a phasing right is the right that a declarant reserves to itself in a master deed that gives it two things, essentially: the right and opportunity to permanently occupy the land of the common area with a unit that it would construct, and the ability, when it submits those units to condominium status, that it basically adds those units to condominium status, that it has the right to reallocate the property interest.
The percentage interest, right, the percentage
exactly.
interest.
So
okay.
The reason,
and we assume that the phasing, I get that, and that sounds to me like what I figured out. So now, is that a property right? It's a property right because?
So it's a property right, Your Honor, because it gives the declarant the ability to permanently occupy land that it does not own, so like an easement, Your Honor. And it also gives the declarant the opportunity to reallocate, essentially in a deed that it conveys to a unit owner, an ownership interest in that land. So the land.
Mr. Moriarty, what if it's not an easement? And as
Yeah.
Mr. Devine tells us, it's a fee simple interest?
Well, the case that is relied upon to support the proposition that it's a fee simple, and the argument is it's a defeasible fee. That's the Quayler case. If it were fee simple, the universe would be different, Your Honor. Fee simple, subject to a condition subsequent or subject to defeasance, would be subject to the conditions that are created in connection with the creation of that instrument. And if there is a defeasance, it's affected. And if there isn't a defeasance. But, Your Honor, there is no support for the proposition that a phasing amendment is a future interest or a defeasible fee. The Quayler case, upon which the bank relies exclusively for that proposition, did not involve an assessment of whether or not a phasing amendment constituted a defeasible fee. To the contrary, Your Honor, the Quayler case analyzed whether a reserved right to remove land from the condominium would constitute a defeasible fee, and the court concluded it is a defeasible fee.
You assume that this is a property right, and I take it that you assume that this right is exclusive in initially the declarant and now the bank as the foreclosing mortgagee, right?
The bank has not foreclosed, Your Honor, but yes, it's an exclusive right possessed by the declarant. So the declarant.
No one else can initiate the build out of the whatever it is, 24 lots that have not been built.
Not while it's possessed by the declarant, Your Honor. No. So the two steps in the process are the declarant has a fee simple interest in land, or in some cases, a leasehold interest in land. It's possessed of that. It chooses to submit that land or that interest to condominium status by way of a master deed. And the law recognizes that it can reserve certain rights. So it can reserve from the master deed an easement. It could reserve other rights. One of the rights that the law clearly recognizes that the declarant can reserve is the right to add additional units to the condominium over time. So in that circumstance, of course, it's the declarant's, because the declarant had the fee simple, had the ability to reserve from the submission the opportunity to add additional phases. Of course, once that right expires, the law, General Law, Chapter 183A, Section 5B23, provides to the association, the organization of unit owners, the ability, with a vote of 75% of the owners and 51% of qualified first mortgagees, to revive and grant.
Does the law say that a phasing right has to expire?
No, Your Honor, it does not.
Because we're in a world that I'm not as familiar with as you two guys are. But it seems quite odd if I'm buying into a condominium complex where, and particularly in this case, it's been held that all of the common area that was initially, or all of everything that was initially granted is now in the hands of the unit holders, except this phasing right permanently. So no one has the ability, apparently, except the declarant, to continue that build out. And that's the position that the other side is taking, right?
Yes, and it's the
and you want it to expire, but there's no law that says it has to.
Yes, but that, Your Honor, is two different questions. There's no dispute in this case that the Beechwood court has concluded that the phasing right persists because it was not linked to an expiration period in the master deed. But, Your Honor, that is always the case when extinguishment for want of purpose is analyzed. The first question that is answered is, well, there is still an easement here that exists, but it has no purpose. Then you move on to the separate question whether or not it should be extinguished for want of purpose. So to be clear,
did we call it an easement in Beechwood 1?
No, there was no analysis whatsoever undertaken with regard to the nature of that right. USALLIANCE argues that the Beechwood court was precise in its avoidance of determining the nature of that interest as an easement. But the reality, Your Honor, if you look at the issues that were presented to the court in Beechwood and what the Beechwood court actually held, the issue was not presented. In fact, the court remanded the question about whether or not it should be extinguished to the trial court.
Well, I thought one of the more important parts of your briefing was comes about 20 pages into a 54-page reply brief, and I still don't understand why that happened. But you said, but it doesn't matter what we call it, because the question is, as a matter of public policy, should it continue to exist, right?
That is yes, Your Honor, but the support
and
for
the
that,
cases that you're relying on that come out of the easement law are cases, shoot.
Justice Englander has created his own glitch.
That's what you get for waving your hands while you're talking. Sorry about that. The cases you're relying on are easement cases, but basically you're saying that there's a public policy here, which is when it no longer has value, it should disappear.
Right. So the reason that we've focused on easements, and we haven't said it is an easement, Your Honor. We've said it's in the nature of an easement. And we've also analogized to mortgage interest. We've also analogized below, at least, to the trial court, to restrictions. And we do cite restriction cases in our papers, but it is most closely linked to an easement from the plaintiff's perspective. So we focus on the easement. But the reality is,
are you clinging to the land court judge's view that this was a profit a prendre?
No, Your Honor, not at all. So in fact, the commercial wharf case, which is cited by the land court as a but-see, clearly from the plaintiff's perspective indicates that this is not in the nature of a profit a prendre, but only because there is no resource that's being removed from the land. What's being extracted in terms of value is really economic. I mean, I will note that the application of these principles applies equally if it were a profit a prendre, but that is not our position. The position is that there exists this encumbrance that arguably would persist forever, that prevents the use of this land in an efficient way, and it prevents the association from reviving its phasing right. And to get back to
is that problem a result of a drafting error? I mean, is the problem that the 7 years should have been included in the construction easement? I mean, in the phasing right paragraph, as well as in the construction easement?
Your Honor, this will not be reflected in anything in the record, but from the plaintiff's perspective, yes, there was a drafting error. The appeals court in Beechwood determined that the phasing right did not expire because it was not linked to the 7 years. But that 7 years, you will see repeatedly in recorded phasing, recorded master deeds that have phasing amendments, because for an extended period of time, Fannie Mae and Freddie Mac required to comply with their guidelines a 7-year expiration period. So that's why you see that 7 years in so many master deeds. That is no longer required, but in this instance, yes, from the plaintiff's perspective, the preservation of a phasing right after 7 years, when the parties clearly contemplated the ability to construct the units would expire in 7 years, in a master deed that says the units can't be submitted until they are substantially completed, yeah, it is a meaningless preservation of that phasing right after 7 years, and it should have been more clearly linked to that expiration period.
Well, you say it's meaningless, but it has value. I mean, you guys want it.
Yes.
That's what this case is about. Your clients want it.
Absolutely. And that is precisely the point that the plaintiffs make with regard to the court's reliance upon this business exchange between USALLIANCE and the association. Your Honor, in every circumstance where there is a servient estate that has gone through the trouble of filing a lawsuit to extinguish an easement that burdens its property, it would be fair, if not impossible to conclude otherwise, that there is an interest possessed by the holder of the serving estate. They want it gone. So if that were the case, it would have value and purpose in every circumstance where a serving estate holder was looking to extinguish it.
Thank you.
Thank you, Your Honor.
Mr. Devine.
Okay, thank you, Your Honors. Charles Devine for the defendant, U.S. Alliance Federal Credit Union, who's the mortgagee holding a security interest in the phasing rights described by Article 4A. I would like to just follow up on Attorney Moriarty's definition of a phasing right. And yes, it is the right to complete development in phases. And there is, as each phase is developed, a reallocation of the common area interests of the remaining unit holders. Usually the purpose for phasing is usually to accommodate the developer's cash flow, financing and sales, so that he's not developing the entire development at once. He's doing it in these separate phases and selling off the units and financing the rest of the unit. That's also done for convenience with the mortgage company, which then issues financing and loans based upon the phases that are being developed. Now, in this particular case, the 7 years had nothing to do with a Freddie Mac or Fannie Mae requirement. This was not a loan that was being sold to a secondary market. This was a loan that was originated and held by U.S. Alliance Federal Credit Union. It was one of the first commercial loans that they did, and naturally they did not have the processes in place to discover and actually drafted master deed that was prepared by counsel. But the proper starting point, really, for my argument here is the Queller versus Skolrin case, which sort of is the foundation, I think, of both parties' briefs. And in that case, the court noted that a grantor, a declarant, has the right to place limitations on a conveyance and to create a conveyance that's less than a fee simple absolute. In the Queller case, those retained phasing rights that expired, causing the property to revert
Well, you
when
call
they
it phasing
expired.
rights, but I didn't, that's not the way I read it. The only reference to phasing rights that I saw was really in a footnote in Queller. And I mean, your brother says, look, Queller's a different case. Queller is a case where the rights in the land reverted. That's not what happened here.
This is true. The rights in the land that were remaining after the phasing rights were exercised or not exercised reverted. So yes, but the SJC, in describing the rights of the declarant to retain rights, said that that's appropriate under the statute. In that case, in the Queller case, it was a defeasible estate, a defeasible fee, and the court said, as such, those retained rights were not part of the conveyance. They belonged to the declarant alone, unless otherwise stated in the master deed. That's where we come. That's when now we come to the Beechwood case, and in Beechwood 1, the appeals court, the first appeals court, did define the rights.
I'm not sure this answers the question that we have in front of us for the following reason. Let's assume that everything you just said is accurate, that a reading of Queller means that the phasing rights in question were retained by your client. Don't we still have the question of, okay, what happens to them? What are they? And can they be extinguished because they can no longer be effectively practiced?
And I think that my position is that Beechwood 1 answered that question. So Beechwood, I'm calling the first appeal go around in this case is Beechwood 1. The Beechwood court says, quote, the rights reserved by the developer did not, by operation of law or the master deed, become part of the condominium units or common area. That's at page 93 of the decision. So the court defined those rights as not being conveyed at all. So we have a difference now between the phasing rights in this case, which are not conveyed at all, were retained by the developer, and never became never became part of the
Right,
condominium.
but they can still be a burden on the rights that were granted because all the other fee rights were granted, right? The condo association owns the fee simple for the entire areas in which the phasing rights would be impactful, if you will.
Yeah, so the use of the word burden, I would dispute that because there really is not a burden because everybody went into this deal with eyes wide open. Every purchaser of every
I'm
unit.
using the word burden in the way that I learned it back in first year property, and I don't want to tell you how long ago that was, but it's a stick out of the bundle, right? They have didn't Attorney Moriarty correctly identify what that right is? It's a right to go in and build out those units and change the way that the condo percentages are effectively allocated after it's built out.
Yes, and that's written into
isn't that a stick out of the bundle? I mean, I guess it's a property right, but it is in the nature, it's a burden in the nature that an easement is a burden. It is something that means that the condo association doesn't own all of the rights in the common area. It doesn't because your client still has some.
Yes, I would agree with that. So in that context, you're absolutely right, Your Honor. And everyone who purchased the unit knew of this going in. So the fact that these rights, these bundle of rights we call phasing rights, were retained by the developer and not owned by the condominium should be no surprise to anybody. It is the law of this case because Beechwood 1 did find it. So
It still doesn't. I mean, I think what we're hearing is a fundamental public policy argument, which is if what happened is your client retained these rights, your client should not be able to retain them indefinitely where your client does not have the present ability to execute on them. Because otherwise, no one can build out those 25 units if your client can't. Forever,
well,
right?
Okay, the standard is not whether, the standard in any abandonment scenario is not whether the holder of the rights has a present inability to execute. The standard is whether it is impossible to execute the right. So the comparison should be, is it impossible or is it not impossible?
Okay, and I understand that, and that's a really good argument by a good lawyer. But what about the problem that I just presented? Aren't you essentially arguing that these, I forget how many it is, 24 units that haven't been built, 25, cannot be built unless your client chooses to allow it to happen forever? So we have a condo association, it's sitting there, it's got all this area, and it can't do anything unless your client chooses to do something about it.
Well, it's the way that the trial court judge described it. You know, I get a brand new pair of roller skates, you get a brand new key. That old song from the 70s, if anybody remembers that. The fact is
Only
that
Englander.
he stated that, you know, the parties have to get together and have to negotiate a solution here, because the way that the law comes down is that each party has these definable rights. One party has the access and the other party has the right to develop. So, you know, it's not unusual for two parties out there in the marketplace that have two rights that standing alone entitles them to nothing. So naturally there has to be a marriage.
Without going outside the record, can't we assume, I mean, the land court judge talks about this is a question of simple commerce. Let's see if the parties can make a deal. If a deal had been made, you wouldn't be here. Can't we assume that we have to decide the legal issues because a deal hasn't been made?
Well, yeah, well, not getting into any settlement negotiations or anything. That the trust has not been shy about articulating their intention to do the development itself and to cut out the developer and the mortgage holder. So it was my client, the person who holds these rights as his security. So their whole intention is to cut out the security they've known about since day one, and to develop themselves without having to pay back the loan. So when you look at the public
something
policy
related
considerations,
Mr. Devine, related to what Justice Englander was saying, how does the construction easement in 4BI come into play? Because I think you'll agree that expired in 2014. Even with your phasing rights and you don't have a construction easement, what effect does that have?
Well, the fact, well, if a deal is struck, there are many ways that the construction easement can be revived. I mean, under the statute, 75% of the owners can vote to amend the master deed. Under the master deed itself, 66 and a third percent can do it. Presently, if there's a vote, there's never been a vote.
Let me just cut through this. It's the old story about now we're just dickering price. I'm assuming if you guys are willing to pay enough money, that you could buy back the right to construct if you were willing to give the condo association members enough money. I'm assuming that that's the case. It's just a question of how much. It's probably prohibitively expensive, maybe I don't know. But I'm not sure that that answers our problem. I think Judge Meade is putting his finger on it in a different way by saying, look, you used to have the right to do all this. You don't anymore. Now what do we do with what's left? Because I have these old maxims running through my head. The law abhors a forfeiture, and the law does not wish someone to have property that can't be used. I can't remember exactly what that maxim is, but that's what it meant. And they run against each other in this case because the forfeiture is Attorney Moriarty wants the forfeiture. You want a situation where the land potentially could not be used.
And that's not unusual coming out of Massachusetts courts. There are cases out of these courts that suggest that a landlocked piece of property that sues to try to get an easement to the public road can't get that easement. Their land's going to go fallow unless they do a deal with the surrounding owners. So that's not
an easement by necessity. I thought that was exactly the context in which you had an easement of necessity. If you had landlocked property and you only had one way to get to a public way, am I wrong?
There are cases that have denied that have suggested that the conditions for an easement by necessity do not exist because of the history of the conveyances and the way that the property sits presently. I can't cite the case off the top of my head, Judge, but I'd be happy to do some research after.
But you want those cases to exist.
The fact that this case is being described as an easement, and it is not an easement. An easement is a grant. An easement is a grant is a grant of property in which a right then is either granted back either contemporaneously or previously or even subsequently. And so the courts look to the language of the grants to determine the nature and the extent of the easement. In our case, we do not have a grant. We have the exact opposite of a grant. We have a declarant that did not grant, expressly did not grant the phasing rights. And therefore, these phasing rights rest only in the declarant. So if they are abandoned, if there is some sort of mechanism to find that there's an abandonment here, where do they go? And why does the trust think that they go to the trust? Because it was never granted to the trust. The trust uses terms like we can revive the easement through 186A section 5B2, but this is not a case of revival. They never had anything. And so they're trying to revive nothing. So if those rights are lost to abandonment, they simply cease to exist. They should not go to the trust in this situation.
I thought that I don't mean to be anything other than respectful of counsel. I thought that Attorney Moriarty keeps citing a section of the condo statute, which he says would allow that right to then go to the condo association. Is he wrong about that?
He is absolutely wrong about that. And what he's not citing, he's citing the condo statute, chapter 183A, section 5B2. And section 5B2 is essentially says that that right, and I should have it here. I have the statute in front of me, and it's really 5B2 Roman numeral 3. It says that the 75% can extend, revive, or grant rights to develop the condominium, provided, however, that the rights to add additional units are set forth as specifically authorized by the master deed. That's the first condition, and they're not in this case. And the trust trust is not authorized to develop itself. And the
Yeah, but
second,
what he's saying is if as a matter of law, there is a expiration of the phasing rights, then this section would come into effect to say that the condo association would have the right to do the phasing itself. And you're now arguing that that's not true, that if the phasing rights expire, they don't exist and nobody can build out the 24.
what he said today, I acknowledge that he said that today. That's different than what he said in his brief. He said in his brief that they're entitled to an expiration, that they're entitled to exercise this statute even without an expiration. And the statute says that these provisions shall not affect the rights reserved by the declarant, except to the extent to which such rights have expired. And it's been determined by Beechwood 1 that the rights have not expired. And so he's trying to shoehorn in this statute into this situation, and it doesn't fit because those rights still exist. They're owned by the declarant in fee. And he's asking this court to divest a fee owner of his property rights. That's basically what this decision is coming to.
Well, only if you assume that what was retained was a fee rather than
Yes.
something in the nature of an easement.
Yes, and I'll rest on my brief on the difference between a
Thank you.
retained right and an easement.
Thank you both. Very, very well argued. Thank you.
Yes, very well.
Thank you very much.
We'll take it under advisement.
The case is now being recorded.
Thank you. Welcome to the appeals court. I am Justice Meade. With me on the panel for this case are Justices Englander and Grant. Each side gets a combined total of 15 minutes. You needn't use all of your time. We've read everything. We do not entertain rebuttal. If we run into any technical glitches, we'll do our best to reestablish the connection, and no one will be discounted any time for such disruptions should they occur. With that, I'll call the next case. It's 20P1042, Christopher Martorelli versus Stuart, RAPP, and others. Mr. Brown.
Thank you, Honorable Justices of the Appeals Court. May it please the court, I am Attorney Steve Brown representing the appellant, Mr. Christopher Martorella. This case concerns a claim for equitable relief under the Massachusetts Impracticability Doctrine, and I'm here to request the Appeals Court to please reverse the decision of the lower court, the land court, allowing a special motion to dismiss my client's action under the list pendant statute. In short, the reason the decision of the land court should be reversed is because Mr. Martorella's action is not frivolous, and it was not found to be frivolous in the order of the land court, nor could it be found to be frivolous. The special motion to dismiss the statutory creation, part and parcel with the list pendant statute that was legislated as a mechanism for property owners to get rid of cases that are completely unsupported by facts and or have no arguable basis at law, and lawsuits that are only filed to jam up property with a list pendant and for no other reason. That's not what's happening here. As the Honorable Justices know, Mr. Martorella and the petitioner, appellee, Attorney Rapp, entered into a purchase and sale agreement at a property sale by auction on February 14th, 2020. Within 2 days, Mr. Martorella had paid the $182,000 deposit. At that time, neither Mr. Martorella nor Mr. Rapp expected nor assumed the risk that within the next month and a half, the governor of Massachusetts would declare a state of emergency.
Counsel, the PNS didn't have a financing contingency. So if you ask us to apply, to rule that the land court judge should have applied the impracticability doctrine, aren't you essentially asking us to read a financing contingency into every PNS?
No, Your Honor, and I thank you for cutting straight to the crux of the point here. And the land court judge inappropriately and unduly focused on the lack of a PNS, which is inapposite to the consideration here. Mr. Rapp stated in his motion to dismiss that it's not the norm for sales at auction to have PNS agreements, and in his appellee brief, he conceded that had he been asked for one, he wouldn't agree to one. And from a legal point of view, as far as remedies are concerned in this type of situation, the first thing to look for would be a financing contingency. If there was a financing contingency, there would be no reason to have the impracticability doctrine. We wouldn't be here. If there's no impracticability doctrine, the next thing to look for would be a force majeure clause. If there's no force majeure clause, then the appropriate remedies to pursue would be the impracticability doctrine or the frustration of purpose doctrine. So the fact that there wasn't a financing contingency in this case, rather than be a justification to reject it, it's the whole rationale for why we're here and why we're arguing the
counsel. I'm not sure I understand that. I understand you made the argument, but I'm not sure I understand why it's right. Your argument is that it was impractical, impossible is another word that gets used in the cases, for your client to comply with his contractual obligations. The contractual obligations were to deliver $1.8 million on a date certain, which I think originally was March 14th. Why was it impracticable for him to do so?
Well, first of all, Your Honor, Mr. Martorella was observing government-ordered self-quarantine orders. So within the impracticability doctrine, which states that performance under a contract is excused on the ground of impracticability if the hardships or risks are so unusual and have such severe consequences that they must have been beyond the assignment of risk inherent in the contract and beyond the agreement made by the parties. So the fact that there would be government-ordered self-quarantine orders during the duration of when a reasonable homeowner would have to—
I understand this argument, and I understand the next piece of the argument, which was, and while he was doing that, his wife went into the hospital for a month and almost died.
Correct, Your Honor.
I understand that, but that seems to me to be a different argument than one that says, I couldn't get financing. It seems to me that there are two arguments being made for impracticability. Am I right about that?
I cited the language in the Mishara case where the court in Mishara said that when it comes to the impracticability doctrine, that all the specific circumstances of the case have to be taken into totality in the consideration. And so my argument is that the observance of the government-ordered self-quarantine rules, the personal crisis of Mrs. Martorella being intubated and being in the ICU unit, in part and parcel with the essentially the shutdown of the entire country. This was in the earliest days. In fact, during the pendency of the PNS, that was the time period where the governor and the president declared states of emergency.
Would you agree with me that these arguments all go to a temporary hold on the obligation to pay?
I'd say that they go to a temporary impracticability, which is recognized under Massachusetts.
So in one of the briefs that I read, not actually the briefs to this court, but a brief to the land court, you actually asked that you be excused entirely, that your client be excused entirely from the PNS. Is that relief that you still seek?
That's one of the claims in the alternative in the verified complaint. We asked for either the the PNS to be declared unenforceable, in which case my client would get his.
What would be the basis for him to be excused entirely from his obligation to pay, as opposed to simply a delay as a result of the circumstances?
Well, the impracticability, I'd say reading the impracticability doctrine, that the circumstances meet the requirements, and so either he would be if we leave it in the judge's discretion, it's an argument in the alternative. So on the one hand, we ask that a continuance be given. There are actually three things we ask for in the alternative. The second is that an equitable order from the judge that the commissioner work with Mr. Martorella in order to get his financing in place. And the third option that we'd ask for in the judges as the court sees fit, to declare the PNS unenforceable. And the thing is, Your Honor, the way this motion to dismiss falls procedurally, there's been no discovery, there have been no responsive pleadings, there's been no evidentiary hearings, and this is instead of the special motion to dismiss was actually filed on the same day my client filed his amended verified complaint. So we were expecting to flesh out
I don't have a copy, unfortunately, of the special motion to dismiss. Was the only basis for it so there could also be a motion to dismiss under 12B6, but was the only basis for it chapter 184 section 15C?
Yes, Your Honor.
Counsel, you argue that the land court judge's findings didn't sufficiently make a finding of frivolousness, but he quoted from the statute, including the word frivolous. So why isn't that sufficient?
Well, that was in his statement of the law, but he quotes the statute, but he never states that the amended verified complaint is frivolous. He says that the commissioner fails on his jurisdictional argument, but he prevails on his argument, and then the judge goes on to completely misquote the statute, and I argue apply a lower standard than what's required under the statute. He says, and I'm paraphrasing, but essentially what the land court judge says is that the commissioner fails on his jurisdictional argument, but he succeeds on whether or not the plaintiff has stated a claim under Massachusetts law for the relief he requests. Forgive me for paraphrasing, but the point is what he doesn't say is, I find this action to be frivolous because A, it has no factual support and it has absolutely no arguable basis at law. Those are the statutory prerequisites to allow a special motion to dismiss in this situation. And the judge didn't bring himself to type those words because he couldn't have. It's not frivolous. And another thing, Your Honor.
Attorney Brown, I write them out longhand, so that might have been actually what was the problem.
Thank you. Me too, but I eventually typed them out. But one thing Your Honor might have noticed is a discrepancy between the appellee briefs and my appellant brief as with regard to the standard of review. This is an interesting question here. I don't think it really changes the ultimate result. However, in looking at these cases, I really think there's been some confusion with this constant refrain back to the anti-SLAPP, the anti-SLAPP standard, and you'll see that the appellees, when they're arguing the standard of review, they cite this Gallipoli versus Watchrock case, but the rationale for applying the abuse of discretion standard that case uses is that this is a Section 118 appeal, and the standard of review on that type of appeal, the interlocutory appeal, is abuse of discretion. But I believe the case law is that if an appeal can be under 118 or the panel standard applies. And then furthermore, there's this trend of the cases such as Ferguson versus Maxim, where they say, well, we just look at the anti-SLAPP cases, and whatever they do, we're going to do that. And then they cite to Reichenbach versus Haydock. So that's an anti-SLAPP case. But in that case, they say under the anti-SLAPP statute, it's a two-prong rule, and one prong is.
Mr. Brown, before you, we'll handle the standard review.
Okay, thank you.
And I apologize if you said this already while I was reading my notes, but is your issue in a possibility based on timing, or are you saying the pandemic forever made it impossible to get financing?
No, it didn't make it forever impossible to get financing. It was based on the circumstances at that time. I'd say
and all the parties agreed the time was of the essence in this exchange, right?
That was the language in the contract, but the pandemic wasn't foreseen, and it can't be fair. The risk of the pandemic can't be fairly thrown upon Mr. Martorella or the commissioner, for that matter.
And as Justice Grant pointed out at the outset, there was no financing contingency.
There was no financing contingency, but there couldn't have been one.
You could have put one in the P&S agreement.
No, the commissioner said that in his filings that it's not customary to have one at an auction, and had one been requested, he would never agree to it.
I don't know that we need to accept that. Was it prior to the time of the auction? Was there notice to the bidders that there would be no financing contingencies allowed?
To that, I can't answer definitively, Your Honor. But I think these are things that would have been fleshed out in discovery, and it just gets back to whether or not at this point in the game there can be a determination that the case is completely without merit and it's frivolous. And I'd say that conclusion can't be reached. It's not frivolous. It's got to go forward. Thank you, Your Honor.
Thank you, Mr. Brown. Mr. Brangwyn, you're muted.
You need to unmute.
Thank you. Good morning, Justices. Michael Brangwyn from the law firm Fletcher Tilton on behalf of appellees, Attorney Stuart Rapp, Commissioner, and Attorney Loeb is going to be taking the final 5 minutes. I think that the key issues here, to focus in on the key issues, are that I don't think it's in dispute that Mr. Martorella's claims, I think he would agree, are entirely dependent on the application of the doctrine of impracticability. And simply put, that doctrine does not apply under the circumstances of this case.
The only basis for your motion to dismiss 184 section 15C?
Yes, that's correct.
But you have to show that his claim was frivolous.
Yes, Your Honor, and that's a good point. I think that based on the appellant's brief, he seems to take issue with the fact that frivolous is maybe a harsh term, but really frivolous in the statute, the claim is frivolous because, and then the statute goes on to list 3 bases for which a claim can be found to be
no arguable basis in law.
Yes, Your Honor, and that is the key, I think, piece here. So really the court only needed to find that the claim was devoid of any arguable basis in law.
He says in a emergency motion filed at the appropriate time, I can't close. And one of the reasons is that my wife is in the hospital, and in such circumstances that she's in intensive care. Is that a basis for temporary impracticability?
No, Your Honor.
Why not?
Mrs. Martorella is not mentioned in the contract. She was not discussed at the time of the formation of the contract.
Right. But he has a wife, and he says, my wife is in intensive care. I can't close right now. I need some additional time.
Well, Your Honor, if I could.
That can't be a basis for impracticability?
No, it cannot, Your Honor. And it's because in the contract, Mr. Martorella, not only was there not a contingency clause, but the contract expressly provided that this agreement contains no contingencies. And if the sale as contemplated is not.
But surely one of the contingencies, since there's an express provision in the contract that your client is going to deliver the deed at his office on a particular date, one of the contingencies was that Mr. Martorella would be in your client's office to receive the deed.
Well, Your Honor, I think that.
I mean, isn't that an implied contingency?
I think that Mr. Martorella could have completed this transaction, but for the fact that he couldn't obtain financing.
No, you're misdirecting my questions. I'm not talking about financing at all. I understand your argument on financing. I'm talking about the fact that the suggestion that there's no contingency can't be right, because one of the contingencies is that Mr. Martorella and your client were going to show up and exchange money for deed. And Mr. Martorella then notifies you, my wife is in the hospital in intensive care. Can we please have an extension? Isn't that a basis for an impracticability case?
Well, Your Honor, I will note that the commissioner did agree to 2 extensions prior to the third.
Total of 3 weeks. That's right. And his wife was still in intensive
with
care.
Respect, Your Honor, with respect, if we focus on the impracticability doctrine, I would direct the court's attention to the restatement section 261, which is the general rule, and specifically comment E, which I was looking at this morning. And there's an idea of subjective versus objective impracticability. Subjective being, I personally cannot perform my obligations, and objective meaning that nobody under the circumstances could perform the obligations. No human being could perform the obligations. Here, the impracticability was subjective to Mr. Martorella alone. It wasn't that financial transactions could not take place in any fashion. In fact, if he had
as a matter of law, this argument you're making has to be as a matter of law, because you're asking it to be dismissed. And it's even worse than that. And I really use the word worse, because your argument isn't just as a matter of law. It's as a matter of law, it was frivolous for him to make the argument.
Well, Your Honor, I really think that the statute, the language of the statute, although perhaps frivolous, the word chosen by the legislature has a harsher meaning, but it's defined as no arguable basis in law. This doctrine does not apply under the circumstances of this case, because it was not impossible for an individual other than Mr. Martorella to arrange for a wire and in a transfer of the deed. The transaction could have been concluded. The only reason that it wasn't was because Mr. Martorella individually, subjectively, was unable to obtain financing.
And the reason that your client chose not to follow the contract and actually deliver the deed in his office was what?
I believe that Mr. Commissioner offered.
Is that a doctrine of impracticability?
I believe that he offered as an accommodation to accept the deed, to arrange for an accommodation under the circumstances. But the
Suppose Mr. Martorella had said, no, I want to do it in your office, Mr. Rapp, like the contract says.
That would not have been prevented by the orders in place at the time, and that hasn't been pled by Mr. Martorella. The governor's orders, at least as I understood them, closings were taking place. Transactions such as this were allowed for this very reason, because time is of the essence. So if the deed, in fact, if Mr. Martorella insisted that I will bring a wire, I will bring a certified funds, or I will arrange for a wire, but I'd like to meet in your office, that was possible. And I think the option for a paperless transaction was an accommodation, not an impossibility. And I'll just note, Your Honor, on the issue of certainly the result, I think, as the lower court recognized, may seem harsh here, but I think what the justices hit on earlier was that Mr. Martorella, even if a financing contingency was not an option in this contract, it was even simpler than that. He could have chosen not to bid on this property and agreed to perform with no contingencies attached. It was as simple as that. He chose to accept the risk that if he could not obtain financing through whatever means, that his deposit would be forfeited. And the case law supports this. The Waters case is essentially right on point in that this is not an appropriate basis for the application of the doctrine of practicability. Mrs. Martorella, again, the circumstances under 262 are inapplicable because she was not mentioned in the contract. And really, Section 262 applies under circumstances where the individual is performing some unique circumstances. It doesn't expressly say that in Section 262, but all of the examples support the idea that the indispensable party, death or incapacity of that indispensable party, really needs to be a material piece of the contract. So I would submit that that section of the restatement also does not apply here.
Counsel, what do you say in response to Mr. Martorella's argument that is an inconsistency in the judge's finding that of frivolousness when the judge also says that the result here was harsh and discomforting? Is that an inconsistency?
Well, I don't think it is, Your Honor. Sometimes the application of the black letter law results in unfortunate circumstances, but that doesn't change that the doctrine does not apply here. And I think with respect to counsel's argument on the appropriate standard, the lower court did in fact state the standard when it, so I would direct the court's attention to a recent decision, Russell and Associates versus RFF Family Partnership, 958 NE2D 1181, specifically footnote 2. And a very similar argument was made that the judge didn't specifically apply the correct standard. And the court found that the exact same standard, the no arguable basis in law standard under 184 section 15C, and the court said it was stated when the lower court explained the law, and there's no reason to think that where the lower court clearly was familiar with the appropriate standard, it was misapplied in that case, and I think the same goes in this case. The judge clearly was issued a well-reasoned decision and was familiar with the standard that he was applying under 184 section 15C.
So as I'm hearing you argue this, and the argument is whatever happened to his wife is irrelevant. His ability to, if he personally has the ability to close on a particular date, the fact that his personal circumstances are such so that let's just say no reasonable human being would be expected to necessarily be there. Doesn't matter for impracticability doctrine? It's that harsh?
Well, no, that's exactly my point, Your Honor. It isn't whether Mr. Martorella personally, because of his own circumstances, could not close. It's whether anybody as an obligor in his position would have been able to close. And the fact of the matter is, any number of individuals would have been able to arrange for this transaction to close either through their own funds or whatever the case may be, where there was not a financing contingency in place. The only reason Mr. Martorella, the root cause of the reason Mr. Martorella could not close on this transaction is because he did not have financing, and he agreed to assume the risk that he could not obtain financing for whatever reason.
We're going to hold you there. Thank you very much.
Thank you.
Mr. Loeb.
Thank you, Your Honors. Jeffrey Loeb on behalf of Mr. Stark and Ms. Donaldson. I want to start with the questions that Justices Grant and Englander just posed and direct the court to footnote 1 in Judge Vey's order on the motions for attorney's fees, which I have, copy I'm looking at is pages 58 and 59. Attached to my brief, in the appendix to my brief, or the addendum rather. First of all, in the last paragraph of that footnote, Judge Vey responds to some degree to Justice Grant's question and points out that he did not observe that he was not saying that this was harsh and discomforting. That yes, he used those terms, but that's not what he was saying in terms of the result here. He also points out that some of the argument that the extension argument to some degree to talk about what Justice Englander is asking about was not argued. That the argument made at the trial court, the argument made in response to our special motion was couldn't get financing, that he couldn't perform.
I'm sorry, I read it. They say more than that. He talks about at length about the situation with his wife.
Oh,
He
yes,
does not just argue he couldn't get financing.
I agree with Your Honor. He talks at length about the issue with his wife, but the law is clear with respect to impossibility. She's not a party to the contract. So that while, to use that word, to come back to the term harsh, and that may feel like a harsh result, the law is clear that you have to be a party to the contract who's impacted. She is not a party. She could have been, she's not. So therefore, there is no basis in law or in fact.
Well, you say the law is clear, and I have to say, maybe, but what your brother just cited to us was a provision of the restatement, not any Massachusetts case, which he says adopts an objective rather than a subjective standard. And I don't recall reading anything about that in the briefs in this case. So when you say this is frivolous, and I ask some questions about how frivolous it is, and the answer you give me comes from not Massachusetts cases, but the restatement and a distinction between subjective and objective, I start to wonder how clear it is, counsel.
I'm not, what I'm going to respond by saying, Your Honor, is that when you look at Judge Vay's analysis on the issue that Your Honor has raised as to the extent to which we have to take into account Laura Martorella's illness and the fact that Laura Martorella is in the hospital, Judge Vay clearly lays out the law as to why that's not relevant to this inquiry, that with respect to this defense, while it is relevant in a real world sense, and I understand Your Honor's concerns and your discomfort with it, but as a legal standpoint on the issue of impracticability, she's not a party to the contract.
And counsel, I completely understand I completely understand the argument, but fitting it into the notion of clear or frivolous, it seems to me is more difficult. Even if we were to agree with you that it has to be an objective standard and that the circumstances that Mr. Martorella was facing at the time with respect to his wife are irrelevant. Clear and frivolous, really?
There's frivolous under the definition as set forth in the statute that there is no basis in law or in fact. There is no basis in law. When you take a look at the facts in this case, as Justice Grant asked at the very beginning of oral argument, is there a finance contingency? The answer there is no, there isn't. We then have time is of the essence. You can't, a buyer has no right to step in and do what he was trying to do and basically demand an extension. If you take their argument, and I know I have a couple seconds.
Well, you surely can't blame him because he's put $183,000 down and then something happened that hasn't happened in any of our lifetimes. We had a worldwide pandemic. It completely upended the financial markets entirely. You surely can't blame him for making the argument.
Not blaming him for making the argument, Your Honor. I'm simply saying that
it was frivolous.
No, I'm saying it was frivolous as defined under the list pendant statute, that there is no basis in law or in fact, because if you take his argument the next step, it means no contract entered into during the pandemic can be enforceable.
No. That's why I asked the questions right at the top, because I did see them argue that they should be relieved entirely from their obligation, but that's not really the argument that they made principally either to the land court or to this court. Their argument was not that they should be relieved entirely. Their argument was that they should get a temporary extension.
Well, except, Your Honor, there is no basis for a judge to order a party to extend a purchase and sale agreement by 90 days. That in and of itself, there is no arguable basis in law for that.
Sure,
I-
but you're saying that there would be no authority for a temporary impracticability? I read the case that Judge Vey cited that suggests that there is such.
No, but what I'm saying is under the purchase and sale agreement, where an agreement is, where there's time is of the essence, a court does not have the authority to order that 90, the judge doesn't have the authority to order that 90-day extension.
But then that would suggest, okay, thank you, I understand.
All right, thank you. We'll take this under advisement.
Thank you, Your Honors.
The case is now being recorded.
Thank you. Good morning. Welcome to the Appeals Court. I am Justice Meade. With me on your panel today are Justices Englander and Grant. Each side is provided with 15 minutes. We've read everything. You needn't use all of your time. We do not entertain rebuttal. If we have a technical glitch, we'll do our best to reestablish contact, and no one will be discounted any time because of that glitch. With that, I'll call the next case 20P 1171, the Fessenden School versus Hub International Limited. Ms. O'Brien.
Thank you, Your Honor. Good afternoon, Justices, and may it please the Court. My name is Rebecca O'Brien, and together with Nick Carter, we represent the plaintiff appellant in this case, the Fessenden School. The Superior Court committed reversible error in finding that the statute of limitations expired in this case in 2012 at the latest, on a record that did not support such a finding. Under the Massachusetts Discovery Rule, the 3-year statute of limitations applicable to negligence and breach of fiduciary duty actions does not begin to run until the plaintiff knows or reasonably should know that it has suffered appreciable harm as a result of the defendant's conduct. The appreciable harm analysis will vary with the facts of the case. And typically it is an individualized fact-intensive inquiry that is not appropriate for a 12b6 motion to dismiss. The Superior Court here erroneously found that the school suffered appreciable harm, or had notice rather that it did suffer appreciable harm in 1995 and again in 2011 or 2012. In 1995, the school retained attorney Regina Rockefeller to defend it against a former student claim arising from conduct that allegedly occurred in 1974. As a result, attorney Rockefeller searched the school records for the 1974 insurance policy and could not locate it. She then learned that Brewer and Lord, the school's longtime insurance broker, used to advise clients, that is prior to the mid-1980s, advised clients that they need not retain their insurance policies for more than 7 years. The school does not dispute that it paid attorney Rockefeller for her services, nor does the school dispute that in some cases, appreciable harm will be suffered when somebody incurs legal expenses. But in this case, the fees that the school incurred for attorney Rockefeller in 1995 have nothing to do with the 1963 to 1973 student claims and the 1979 to 1980 student claim presently before this court. And there's a few reasons for that.
But don't they have to do with the claim that you're making here, which is that you have been harmed because Brewer and Lord provided unprofessional advice regarding the retention of the policies?
Well, Your Honor, first, I do want to point out that the record actually does not reflect the amount that the school paid attorney Rockefeller for her services, and the cases are clear that the harm must be appreciable. And I have yet to see a case that says that all legal expenses incurred constitute appreciable harm. And in fact, the Whipple case that the SJC
Well,
decided—
but you know, I'd like to kind of clear out the underbrush, because at some points you seem to be arguing that there weren't sufficient facts from which they could decide something on a motion to dismiss. And then on the other hand, you attach to your complaint extensive documents from Rockefeller. And you said right at the top here, you don't deny or you don't dispute that you paid her.
Right.
it seems to me, which one is it? Because it sure looks to me like you incurred pretty substantial legal fees. Is there page after page from Rockefeller indicating that she did substantial work in 1995?
Well, Your Honor, what I would say is, but it doesn't say how much we paid her. I understand that the record.
Can't we infer that it was substantial given how much we have in terms of what's in the record now?
Perhaps, Your Honor, but regardless of the amount that the school paid Attorney Rockefeller, we think that harm in this case needs to be assessed on a policy by policy and claim by claim basis. So Attorney Rockefeller defended the school against one student claim that arose in one policy year and that pertained to one insurance policy. And so any harm that the school may have suffered at that time, and again, we don't concede that there was harm, but if it did suffer harm, it must be limited to that 1974 student claim, the 1974 policy, and the 1974 policy period. And that is because there are no facts in the record that suggest that Attorney Rockefeller searched for insurance policies that precede the 1974 policy period or that are from the 1979-1980 policy period. And more importantly—
But doesn't it suggest that, so that's an interesting argument, and it's kind of hard to parse, but you're on inquiry notice right then of a claim against Brewer and Lord as to which you have substantial harm, right?
We don't think that there was inquiry notice. There was a requirement that Attorney Rockefeller at that time needed to search the school's records for every potential insurance policy that—
And I'm not suggesting you did. I'm just suggesting you've got a claim against Brewer and Lord as to which you have substantial harm in 1995. Doesn't that start the clock running?
But perhaps, but only as to that one claim. The school couldn't have known, Attorney Rockefeller couldn't have known in 1995 that decades later, other student claims could potentially arise that would implicate other insurance policies and other insurance policy periods. And so while the International Mobiles case is distinguishable on its facts, and of course it was before the court on a motion for summary judgment and a fuller record, we think that that case says that we want to discourage contingent litigation and we don't want to have insureds take out options on negligence cases. And here we think that if the school couldn't have sued Brewer and Lord and the insurance company for any other student claim, any other policy period, again, because there was only one student claim at the time. And so the school would be suing on phantom claims. Like how could they possibly do that? And so we don't think that any appreciable harm that the school incurred in 1995, again, we don't concede that there was.
The case law is trying to, I understand the argument now about the 1995 occurrence, but the case law is trying to balance this problem that isn't just a plaintiff's problem, it's also a defendant's problem. In 1995, you were aware that you'd suffered appreciable harm as a result of negligence that you claim Brewer and Lord was involved in. You didn't do anything about that vis-a-vis Brewer and Lord. And it wasn't until 16 years later or 17 years later that the issue arose again. And during those 17 years, the defendant, who had they been accused of this negligence in 1995, might have done something different. We don't know because nobody told the defendant. And now it's 40 years later instead of 20 years later. And that's present, that concern is real and it's present in our case law that talks about when a cause of action accrues.
I understand that, Your Honor, and I understand the court's concern. We think that the broader, that question is kind of outside the scope of this appeal. We are just saying—
It's not outside the scope of this appeal. It's right at the heart of what the law should be is when somebody's on inquiry notice and has to commence either a lawsuit or notice to the defendant and a tolling agreement, right?
Right. No, I understand Your Honor's point. I think that this case is incredibly unique because we have one instance or we really don't know much about when this advice was given. But we have one piece of advice, one piece of negligent advice, one that we would submit is a breach of fiduciary duty as well, that has caused multiple harms over potentially decades of different policy periods, and that implicates all of these different insurance policies. insurance policies, other cases are clear outside of the statute of limitations context that insurance policies have to be viewed independently. They have to be interpreted independently. They are individual contracts. And here, I think it's important to remember that what if, regardless of this advice when it was given, what if the school had searched its records for these policies, notwithstanding the advice, and found them? Then there would be no harm. And so I understand Your Honor's concern about inquiry notice, and I understand Your Honor's concern about the defendants wanting some solace in the statute of limitations running. I get that. But in this case, I just think because of the different insurance policies that are implicated, the different insurance policy periods, and the lack of student claims that implicate those different insurance policies and policy periods, that we can't say that a statute of limitations has run before those claims even arise. Before
the claims arose in 2000. From what I think a fair inference from your complaint is that the claims arose by the end of 2012. At least some of them. Claims for years 63 to 73. That's what your complaint alleges, right?
Right.
And that's 3 years before, that's more than 3 years before suit was brought against these defendants.
Yeah, that's right, Your Honor. But again, the amount that the school paid Marcia McLennan is not in the record. And it needs to be, the harm needs to be appreciable. The Whipple case, the SJC Whipple case that the appellees cite in their brief and that the Superior Court cited in its opinion said that the legal expenses need to be significant. And these aren't legal expenses. It was a professional consulting firm that the school hired, but those facts are not in the record. And another thing is that the Gonzalez v. Arsenault case, and that's not cited in our brief, it is a Superior Court case, but it's in the record at page 230. That was decided by Justice Gantz when he was on the Superior Court. That case said that the claims, they can't just be demand letters. They have to be lawsuits. The claims need to be more than just threatened. Otherwise, you wade into the waters of this contingent litigation, in short, taking out options on negligence suits. And there's nothing in the record to suggest, and I'm not aware of the 2011 and 2012, student claims being anything other than demand letters. And so that's another thing to think about, is that when we're talking about the amount that the school paid for Marcia McLennan, first of all, it was also in the midst of negotiations with its insurance companies at the time for coverage, but the fees themselves for Marcia McLennan need to be sufficient to justify the cost of bringing a lawsuit on the basis of those fees.
Let me make sure I understand that argument. That argument is, the record doesn't tell us that the costs that had been incurred were A, substantial, and B, in connection with any lawsuit that had been brought.
That's correct. As to the 2011 and 2012 student claims, that's correct.
And you say that's important, that it's not in connection with any lawsuit that's been brought, because the harm would not be recoverable without that. The alleged harm, which would be the cost of hiring Marcia McLennan, would not be recoverable without the existence of litigation. And that's what you're citing Judge Gantz for, essentially, right?
Yes, but Judge Gantz didn't really focus on the fact that it was recoverable as much as it was appreciable. And I'll explain, in the facts of that case, he said that prior to, the argument was made based on international mobiles, that prior to a lawsuit having been filed, the amount of money that this particular plaintiff had incurred for responding to a demand letter was a de minimis amount that didn't justify the cost of bringing a lawsuit on the basis of those fees.
Well, but that's if you're just responding to a demand letter. But you guys have a history. You know you've got a big problem. And apparently you had a number of demand letters because that's what the complaint says.
Right. No, I understand that. But
you hired somebody who did more than respond to a demand letter.
Well, of course, Your Honor. But again, 1995.
Isn't it inferable from the complaint?
That are you talking about Attorney Rockefeller?
That the work that was done by Marcia McLennan was more than responding to a demand letter?
That's not in the record.
Isn't it inferable from the complaint? Your argument would be no?
My argument would be perhaps, but in this instance, based on the Gonzalez case, the complaint isn't clear, the record isn't clear that these were lawsuits. And I was just explaining the facts of the Gonzalez case because Justice Gans ultimately decided that it was only when the plaintiff, in that case, when the attorney was responding to a lawsuit and would incur the substantial expenses of responding to a lawsuit, that there was appreciable harm. It wasn't when he was just responding to a demand letter, that amount was de minimis. It was when it was a lawsuit. And so that was just, I was just wanting to clarify that in that case, that was when Justice Gans said that there was appreciable harm. And so I just wanted to also briefly discuss just the policy ramifications of 1995. So if Attorney Rockefeller had brought a lawsuit in 1995 against Hub and against, or Brewer and Lord at the time, and against the insurance company, it only would have been able to bring a lawsuit on the basis of that 1974 student claim, because bringing it on the basis of the school couldn't have foreseen that other student claims would arise decades in the future that might implicate other insurance policies. And so we would submit that any other student claims, any other policy periods or insurance policies, had they been part of the lawsuit at the time, would have been dismissed because there was no harm that had resulted because of those policies. And so for those reasons, as well as those in our papers, we respectfully request that the Superior Court, that this court reverse the judgment of the Superior Court and remand the case to the Superior Court. Thank you.
Thank you. Mr. Flanagan.
Thank you, Justice Meade, and members of the panel. May it please the court. It's the focus of this statute of limitations argument comes down to this appreciable harm analysis. The case law cited specifically on page 18 of our brief addresses the very law that's applicable to the circumstances here. And despite the appellant's protestations and arguments and assertions, appreciable harm is defined not necessarily by the amount that's spent, but certainly whether there's an injury or loss and there's a detriment that is capable of being measured or perceived, as found by this court in Vinci. The point at which appreciable harm occurs will vary with the facts of the case, understandably. It's not necessary, according in the Cantu case, it's not necessary for the full extent and nature of the harm to be known. In these circumstances, justices.
Well, you know, that's interesting. Right, that's what the cases say. But isn't your sister right that any claim that was brought in 1995 would not have encompassed the losses that they later incurred in 2011 and 2012?
Well, Justice Englander, the 1995 circumstances certainly put Fessenden on notice, inquiry notice of this issue, that there was advice given at or about that time. They were aware that advice was given not to retain policies for any length of time.
But they don't have any loss with respect to any year other than 1974. They don't have. At that point,
that's correct.
They don't have any of the losses that they would be seeking in a lawsuit against your client now. Those were not incurred until 16, 17 years later.
Agreed.
I think that's a kind of an odd construct to, you know, you're right. The case law says you don't have to know the full extent of your harm. But what if what you know has nothing to do with the harm that you're ultimately suing on?
I'm not sure I understand, Your Honor.
What they knew in 1995 has nothing to do with the harms that they're now seeking, which have to do with the costs that they incurred for Marsh and McLennan going back to 63 to 73.
Well, certainly it was a precursor to what they ended up discovering in 2011.
Had they filed the lawsuit in 1995, they did not know and would not have known during the entire course of that lawsuit about these other losses.
That's potentially true. Although certainly they were put on notice, and most certainly by 2011, 2012, when they had other claims, and I think what was done at the Superior Court level was, and the statement was clear, at least by 1995, perhaps and I'm paraphrasing the court's analysis, but by 2011, 2012, there was notice, there was appreciable harm of the circumstances. It doesn't necessarily have to be a monetary analysis at that point. There was injury and loss and detriment. They had spent money already on an attorney and a different insurance broker to attempt to put together their policies. They were aware that they didn't have policies for the time periods in question and that there were going to be coverage issues. From our perspective, and I think that I don't want it to get lost on the court that 1995, but the 2012 at latest, they were aware of appreciable harm. And I think that's
their hiring of Marsh and McLennan. And then your sister says, yeah, but there's nothing in the record that shows how much they spent on Marsh and McLennan. What do you say to that?
Well, I think, again, going back to the case law, not to be repetitive to that point, Justice Englander, there's the appreciable harm is not necessarily measured by the amount. It's not necessary there doesn't need to be a full and extent and nature of the harm known in the Cantu case. The plaintiff need not know the extent of the injury, but that there was negligence and that they caused for a cause of action to accrue. By 2012, that appreciable harm.
There has to be appreciable harm too, not just negligence.
Understood, but they don't need to know the extent of the injury. They need to, at that point, they're aware that there's lack of coverage and they may perceive there was potential for argument that there may be coverage at some later date, but that speculative aspect doesn't negate the harm that they know that they've sustained at that point.
I'm gonna go, this is gonna be a little bit unusual question maybe, but the problem here is that these cases can be brought 40 years after the events. Why aren't those cases subject to a statute of limitations? What is going on there?
You're talking about specifically
what they're seeking claims? Coverage for are lawsuits that are literally being brought 50 years after the fact.
Right. Well, and I would submit that's the purpose of the statute of limitations. And I think, Justice, you had hit on this in questioning my sister regarding this, that this is the heart of why there is a statute of limitations, that there needs to be some bright line or determinative time period so that we don't go so far into the future when memories have faded and the ability to obtain evidence. And specifically, that impacts the defendant's ability to defend itself under circumstances like this. No notice was provided in 1995 or even in 2012. It wasn't until sometime into 2015, and suit wasn't filed to 2016. This is quite precisely the reason why the statute of limitations should preclude an action like this from proceeding, because of the delay that occurred, despite the fact that Fessenden had inquiry notice, that they had been advised by Brewer and Lord, who, by the way, and I don't want this to be lost from our argument, is not in the complaint connected to these present defendants. And that's an issue that the court didn't reach in the Superior Court. But that's another argument. That's the first argument I think that we make in our original motion to dismiss. And the court chose to focus only on the statute of limitations argument, precisely for these reasons. This is an attenuated claim against some unconnected, at least in terms of the complaint, and the plaintiff cannot connect Brewer and Lord, the entity that supposedly gave this negligent advice, to the present entities that are the defendants that are before the court.
That's just a successor liability issue, right? I mean, that's.
Well, it is.
And it wasn't addressed by the judge below.
Right, but it's our position that it could be reviewed, and it should have been reviewed, or at least, at very least, if this was to go back to the Superior Court, the Superior Court should rule on that particular argument. That argument was apparently not considered. We suggested it should be considered. It's not a cross appeal circumstance from our perspective, but it's something that the court should consider, that the successor liability is not pled. It's not in the complaint. They don't connect the negligent actor to the present defendants in this case. And that's another aspect that we want the court to consider. That's the extent of what I wish to argue to the justices this afternoon. I'm happy to answer any additional questions.
Seeing none, I thank you. I thank you both. We'll take this under advisement.
Thank you.
Thank you.
The case is now being recorded.
Thank you. Good afternoon. Welcome to the Appeals Court. I am Justice Meade. With me this afternoon on the panel are Justice Englander and Grant. You have 15 minutes. You needn't use all your time. We have read everything. With that, I will call the next case, 20P 1123 AL versus ER. Mr. Smee, and I remind you, this case is impounded or partially impounded, so please don't use any names.
Certainly. Good afternoon. May it please the court. My name is Zahir Sami. I represent the defendant in this appeal. The defendant was well, let me put it this way. The plaintiff in this case obtained an abuse prevention order under 209A against the defendant originally in July of 2018. The parties were married at the time. That order was issued for 1 year. It was extended again for another year in August of 2019. And then most recently on August 7th of 2020, it was extended for 6 months. The defendant is appealing the most recent extension of the order on August 7th.
What's the status of the order now?
It's been terminated, Your Honor. And I actually, for what it's worth, I did represent the defendant at the extension hearing in January of 2020. And I forget the name of the judge in the district court at the time, but the judge terminated it. So
when you say January 2020, do you mean January 2021?
Thank you for the correction, Your Honor.
We're
Yes.
all in a time warp.
Yes, I absolutely do mean January of 2021. Yes. So that's the status of the order now. I'd like to start by asking the court to consider the second issue that I've identified in my brief, the issue of whether the lower court engaged in an improper presumption that the order should be extended. And if you look at page 18 and 19 of my brief, you'll notice that and even though we're not, appealing the July 2019 order, it does provide some useful background what the judge at that hearing actually put on the record, because it provides, I think, what is a surprisingly direct admission almost that the court was engaging in a presumption that the law does not allow it to do. And what the judge stated was something like, I'll quote, 2 other judges have passed on this and they have not terminated the order. It's hard to imagine a more direct admission that the court was engaging in a presumption that a 209A order simply because—
Is that the same judge who ruled in 2020?
Actually,
no, there were two prior judges. When I read it, I thought he was reciting the procedural history of the case, and how many times it had been ruled on. The judge who issued the extension never said, because it's been ruled on before, I can't rule on it, or I have to rule the same way.
I think he was doing more. If you read the whole context, that statement occurred towards the end of the hearing, Your Honor. And it's pretty clear from the context that he was reciting the procedural history, but he was doing that in a manner to justify why he was making the decision that he was making. He was wrong about one thing, though, because he referred to 2 judges, and one of those judges was the prior district court judge. Another judge that he was referring to was a probate and family court judge, because by that time the parties were engaged in litigation in the probate and family court in a divorce proceeding. And actually, under the orders of the trial court, a probate and family court judge does not have the authority to even terminate a 209A district court order.
But she did modify it by agreement of the parties. So she was aware of the circumstances.
Correct.
Why don't you focus on why you think the extension wasn't justified?
The extension wasn't justified, Your Honor, because first, certainly between the time of the original entry of the order and August 2020, there was absolutely no evidence of any violation of the order, attempt to violate the order, or any evidence of actual abuse as defined by the statute. And the law is very clear that the analysis at an extension hearing of an abuse prevention order must be based on the circumstances as they exist at the time that the extension is sought.
But you can look back.
Certainly, Your Honor.
You can look back. As part of the totality of the circumstances in 2020, the cases, I think, are clear that you can consider what had happened even going back to prior to the initial order being entered, right?
I don't disagree with you at all, Your Honor, and that's the only way to make these sorts of decisions in a sensible manner, because if there was, an attempt on the plaintiff's life prior to the original order, obviously that circumstance has to inform the decision that a judge is making, 1 or 2 years later at an extension hearing.
The second definition of abuse under 209A is placing an individual in fear of imminent harm, right?
Yes.
Okay, so the judge asked AL at the July 24th extension hearing why she thought she was in imminent fear of bodily harm. And she explained, because of his anger, rage, he seems out of control. And later she said it's because his behavior is escalating. So there's direct evidence of her being placed in imminent fear of bodily harm. Why wasn't the judge entitled to credit that?
I completely disagree with that, Your Honor. The evidence offered.
You disagree with that's what the record is, or you disagree with her direct statement of why she's in imminent fear of bodily harm is insufficient?
I disagree that the evidence she offered supports an objectively reasonable fear of serious imminent bodily harm. And the reason is because the only thing that she alleged was essentially speech. She repeatedly testified at multiple hearings.
That's not true.
I don't think, I believe it is true. I don't think the record identifies anything.
Excuse me, there's the incident at the church where he shows up and sits behind her. There's the incident with the paper signing where he's banging on the table, essentially menacing her so she can't escape. And also, I thought quite telling and noticeably absent from your brief is any mentions, and now you told us you were at the hearing, the last hearing, where she's put in her affidavit and then testified to his newfound interest in guns and his target shooting practice and leaving the human silhouette targets for her to find.
That was actually, none of that was mentioned at the prior hearings.
It was mentioned at the extension hearing that you were at.
Oh, I see what you mean, Your Honor. It was, and the judge did not find it relevant. If the court wants me to supplement, and I didn't feel that it was relevant.
Where in the record does the judge say it's not relevant?
The judge says that she's concerned exclusively with what happened between the last extension hearing and the current extension hearing. And she also made credibility findings that she alluded to explicitly, that she believed essentially the defendant's version of the stories that had been recounted at the latest hearing. And
where in the record is that?
Well, I'm happy to supplement the record, Your Honor, but that was after the briefs were filed.
Cite me the transcript where the judge said that, because I read this all yesterday and I didn't see any of that.
Are you talking about the January 2021 hearing, Your Honor?
I'm talking about any hearing where the judge said she's crediting the defendant's version of events.
There's no transcript prepared of the January 2021 hearing. I'm happy to prepare one.
The questions were not about the hearing that you were at in January of this year where it was terminated. The questions were about what's under review now. which was a hearing in August of 2020. I and Judge Meade both understood you to be representing that the judge made some findings about credibility that aren't in the record that I've seen.
Oh, I'm sorry. I thought you were talking about the January 2021 hearing. That was the one that I was at. I was not at any of the prior hearings, Your Honor. So my mistake. I misunderstood what hearing you were referring to.
Well,
Maybe you can
nonetheless,
Who represented?
Nonetheless, the references to the gun shooting exercises and target practice is all part of the record, and you mentioned none of that in your brief.
I don't think that was the basis of any of the orders that were extended, because that all occurred, Your Honor, prior to 2018. And I can tell you what that is. The order, the reference to the gun shooting practice was a situation where the defendant took his sons to a shooting range, and this is the only time he's ever taken.
Is any of this in the record?
Well, no, but I mean,
Your client didn't testify in August of 2020.
I don't believe he did, no.
Right, no, the choice was made not to have him rebut what the plaintiff said. And one of the things that she said is what Judge Meade is talking about.
But let me ask you this, Your Honor. Why is an interest in guns, why does that alone give
Mr.
rise to
Samir, the argument works better when we pose the questions.
I'm sorry, what I meant to say is, I don't think an interest in guns would necessarily give rise to an imminent fear of physical harm. She didn't even testify that there was a gun in the house. All she testified was that she saw, I believe,
well, he'd have to give up the gun in 2017, right? That's a standard part of the 209A. He'd have to give up the gun if he couldn't have access to guns after 2017, right?
He's never owned a gun, Your Honor.
Well, that's not my question.
Yeah, he would have had to give up the guns. But he's never owned a gun before 2018 or after, and there's been no evidence that he ever did own a gun.
But let's assuming he never owned a gun, could his leaving target silhouettes that with bullet holes in them around where she could find them, could that put her in fear of imminent serious physical harm?
Absolutely not, Your Honor. And I can tell you, it's not on the record, but that was the son's, the party's son's target practice sheet to show his mother how proud he was, how good his target practice was. Not on the record, but you asked about it, so I'll mention it for what it's worth. But there's no gun. There's never been any allegation that
if we evaluate the extent, Mr. Smee, if we evaluate the extension order based on what's in the record, which we have to do, could the judge have drawn a reasonable inference that AL was in fear of imminent bodily harm because she'd been made privy to the defendant's handiwork with the target?
No, absolutely not. She has no evidence that that was the defendant's work or whose work that was.
He testified that it was his newfound interest in guns and the target that he left for her, which is all testimony the judge was entitled to credit.
I don't know if that was, there's no foundation laid as to what personal knowledge that was made on. Simply finding a target.
No objections along those lines were made at trial.
And the ordinary rules of evidence don't apply in a 209A, do they?
Not ordinarily.
She's subject to cross-examination. Those points could have been made in cross-examination. They weren't.
Okay. I would still submit that merely having a target practice, a shooting target practice sheet in the home does not give rise to a reasonable fear of imminent physical harm. Having a gun in the house, maybe, but that is all that she offered. She offered nothing more, and she's asking the court to make an inference that she had a reasonable fear of physical imminent harm when that's all that she observed. She never offered anything beyond that as far as the firearms go.
Am I correct that the standard language of the 209A orders would have he could not have a gun, right?
I believe so. I believe that's correct. Yes.
From 2017 on, he could not have a gun.
2018 on, he never has owned a gun, and
you'll notice that was entered in 17. No,
I believe it was July 2018, Your Honor.
Okay, then I made a mistake. I thought it was extended twice before this 6-month extension that we're dealing with. But okay, maybe that's right. Okay.
Yeah. So I don't think that merely having an interest in guns, constitutionally protected Second Amendment right, perhaps, can give rise to a reasonable fear of imminent bodily harm in another. Much in the same way that I don't think simply having or seeing a shooting target practice sheet can give rise to a fear of imminent bodily harm. The rest of the evidence of abuse that the plaintiff offered at any of the hearings was simply just marital arguments over children, over finances. That's not the type of stuff that a 209A order is meant to address. A 209A order is a specific tool for a specific job. It's not the right tool for simply trying to bring marital harmony or lessen the stress in a conflict-ridden marital relationship. And that's really what the order functioned as here. There's certainly, it certainly seems as if the judges thought that the plaintiff had a subjective fear of a subjective fear of harm, but it was not reasonable under the circumstances.
Thank you, Mr. Smee. Your time is up.
Thank you.